observe these public proceedings, and courtroom 1D is wide open if anyone wanted to come on down here, but I understand why people are where they are. Let's just let the YouTube feed start up. And there it is. Okay. Whoop. Someone else in the waiting room. There goes our Hollywood Squares.
That is another one of the principles of RPL, Your Honor.
Okay. And Mr. Allen, as I said, they're welcome to be connecting this way. If you don't think they're going to participate directly, they also can watch on the YouTube feed, but I've got no problem having folks dial in. So this is 2019 CV323051. Where did the motion I was looking at go? And the style of the case in general is Aldous Myers and ACM 3 as plaintiffs. And then we've got a whole roster of defendants, but I believe the primary defendant that we'll be hearing from today is RPL Management, as represented by Ms. Tuttle and Mr. Allen. We do have counsel for Mr. Golhar. And then do you also represent Blue Summit, Mr. Johnson?
I think I do, Your Honor. They haven't played much of a role in this case, but I believe I have filed an entry of appearance for them.
I think you have as well. And how about Summit and Crown?
I do represent them.
Okay, great. But as you mentioned, you are primarily spectating. I reserve the right to call on you if something comes up and I've got a question, but I think having reviewed the pleadings that are at issue today, Mr. Jodecki and Mr. Caskey and Ms. Tuttle and Mr. Allen are going to be able to cover the waterfront. So what I think we're working through today is a motion for partial summary judgment that plaintiffs have filed, and it targets the Ormwood property. And then there is a motion for summary judgment from RPL arguing that it ought to be cut out of the case altogether for reasons we'll cover. And what I want to do is just let the lawyers know what I think it is we're talking about, and then I'm going to hand it over to the lawyers to get us through the two motions. But as I'm remembering this case, Mr. Myers, through ACM3, invested a fair amount of money with Summit and Crown, whose principals are Golhar and Higgins. There were real estate investments. There were all sorts of promissory notes and this and that. And in the end, despite being told he was making money hand over fist, Mr. Myers only got a little bit out of these investments. I think there was another property brought in that was going to make things better when things weren't going well. But one of the properties is the Ormwood property, and RPL purchased it or acquired it from Summit and Crown, or some permutation of Summit and Crown. And the dispute between plaintiffs and RPL is plaintiffs' contention that RPL knew or should have known that there was a forged quitclaim deed and or that RPL is somehow in cahoots with Summit and Crown because maybe they had done business together in the past or continue to do business together. And I'll let plaintiffs' attorneys flesh that out, but really the rub here is, why is RPL in the case if the primary allegations of fraud and mistreatment and malfeasance are Summit and Crown, Blue Summit, which I think was Mr. Golhar's company, Mr. Golhar, and Mr. Higgins? Why are we dragging these other players in? That would be RPL's perspective. And I know that a few defendants have resolved their matters and have been cut from the case, but we do still have, at a minimum, RPL. And today I'm going to hear from plaintiffs' counsel as to why really the RPL piece ought to be wrapped up through summary judgment in plaintiffs' favor. And then RPL's attorneys will argue, actually, we ought to wrap up RPL's piece, but in RPL's favor, and they ought to be cut from the case. Before we dive into that, we need to work through a motion that was just filed by RPL concerning a few exhibits. A couple of the exhibits to me were less alarming, but what I'd like to start with from plaintiff's counsel is a little bit of an explanation as to how they thought that it was a good idea to handle Ms. Stahel, and you can tell me how to pronounce her name, the way she was handled. And granted, I've just read RPL side of things. Plaintiffs haven't really had a chance to respond in writing to that, but what I've read certainly raised an eyebrow or both eyebrows as I was working through the way in which it appears to have unfolded that plaintiffs obtained information from Attorney Stahel, given her apparent connection to RPL. So why don't we start with that, Mr. Tredecki or Mr. Caskey, is your thoughts about RPL's motion to strike or disregard your 3 exhibits. And again, Exhibit B, the only allegation is this is sort of made up out of whole cloth. It's a summary. We can work through that one first, and that should be pretty simple. The other 2 are connected to Ms. Stahel and to me are worthy of more discussion.
Sure, Your Honor, I'll take that. And again, as you noted, this was provided to us yesterday, despite the fact that these documents were obtained and everyone knew they were obtained back in August. We had a summary judgment motion deadline, a dispositive motion deadline, I believe, in November that we extended to December when I was asked to extend it due to some COVID issues on the other side. We then had a response deadline, January 6th or so. And now this comes to us the day before the hearing. So I'm happy to provide a written response if I need to, but let me go ahead and tell you how we get to this point. It starts with the very beginning of the case. I didn't know who Ms. Stahel was. When we went ahead and filed written discovery requests in this case, and you have a set of those, I think we attached them to one of the briefs. I asked for all folks who had any involvement or knowledge of the case. I asked it in a couple different ways. I asked for all communications related to any allegations in the case, the transactions, that sort of thing. And what I got back from RPL were some interrogatory responses that don't identify Ms. Stahel at all. They also don't mention really any involvement by her. We took RPL's deposition and they referred to her, I think, as a closing attorney they used on occasion. Well, we have other attorneys in this case. Ms. Dortch is a closing attorney that we use on occasion. We had the fellow who closed the holiday loan, which we didn't get paid. We went around to all these folks. We had Mr. Brannon, who handled my client's representation early on in this case when the original notes were drafted. All of these folks at one point or another. I didn't know who she was until I sent out, I had some inkling. I mean, you'll remember, I named a couple of attorneys in this case. I did not name her. I named Pavel Dortch and I named Cindy Mack because I saw that there were forged notaries that had come out of their office. All I knew about Ms. Stahel at the time was that she's listed on having prepared one of the blank, one of the forged documents. She's listed at the top, returned to Ms. Stahel. And what I had gathered was that she had probably prepared some of these documents. So I did what I do in these type of cases. I sent a letter and I said, hey, I think you may have some documents. I didn't get any of these documents from RPL, mind you, or any identification of her. I said, I've got these transactions. I think I had a phone conversation with her first. I just picked up the phone and called and I said, hey, this is who I am. I've got this. Can I send you a letter and tell you what I'm looking for? And then you tell me. I said I can take your deposition if I need to, but I'd rather do this. If you're voluntarily willing to produce documents that you have. I didn't think anything of it. I'll be honest with you until well later on. But so I did that, and I get back a stack of documents from her that's about this tall. And she was involved, and you'll hear more about exactly how she's involved when we get to the second half of the fraud allegations. But essentially, we quickly realize that she becomes the centerpiece of this thing. And what happens is she sends me documents.
And when you say this thing, just Ormwood, or your belief is that she's involved with other transactions?
Other transactions.
Okay.
And I get documents. I think we get them sometime in August, the August 22nd, 23rd timeframe, somewhere in there. I ask her about authenticating the documents. Typically, when you send out a document request to a bank or somewhere else, you go ahead and get an authentication. So I think she might live up here or something. She agreed to come to my office, and I got a affidavit that says, that she had the documents. And I said, I'd like to, my initial intention was to have a court reporter there and just do a sworn statement to authenticate the documents. But while I had her, I asked some other questions. And that's what that came out of that. We started to pull documents out as she was sitting there. She explained to me what was going on. What ends up happening here, Judge, and I had contemplated throughout this case of filing some kind of motion for sanctions against the other side, is they just weren't honest in their discovery responses. I'm not even sure that the lawyers know the extent that these folks are involved. They don't identify her. And then they claim, when I ask what the relationship is with RPL to Higgins and to all these other folks, they simply say they're a purchaser of the Ormwood property. Well, the documents that we get from Ms. Stahl show that they're way more than that. What ends up happening here, these folks go way beyond an ordinary lender. What ends up happening is...
So you need to, when you say these folks, you need to let me know who you're talking about.
I'm sorry. The RPL folks, because most, if not all, of the emails that we get in this case, which we didn't get from RPL, are emails from RPL, Summit. I would tell you that Ms. Stahl also represented Summit throughout this process, although I think she was careful to say she didn't. But the only bills that ever seem to go out are Summit's. I'm not even sure these are RPL's documents. But what happens is, essentially what happens is Summit ends up owing RPL so much money across so many projects, and they sit as junior lien holders on some projects as well, that they tell Ms. Stahl to go ahead and prepare, I think it's 6 separate quitclaim deeds. They said, prepare 6 separate quitclaim deeds with respect to this list of properties. And one of those properties is the Holiday property, okay? Prepare, 6 separate quitclaim deeds. I want you to get Summit to sign them to RPL. And then if there are any junior liens on any of these properties, I want you to get junior lien releases on the properties. It turned out, I think there were 2 or 3 properties that had junior liens, one of which was the Holiday property, which was my client's second lien that didn't get paid at closing. And then there was an entirely separate transaction that resulted in a lawsuit with similar facts to what we have. And what they told her was, get these documents, get them signed, and keep them in your drawer.
And they would be
RPL.
RPL.
I believe it's Loveness is the one that communicates primarily with Ms. Stahl.
Okay. Now, I want to make sure I'm staying focused on the right thing.
Sure.
Which properties in your lawsuit that we've got now is RPL attached to? Just Ormwood?
Well, the only one that has a security interest is Ormwood.
Okay.
But it's our contention there's a conspiracy here that goes beyond that, because what ends up happening in the Holiday property, and I was going to talk about this on that side, is what ends up happening in the Holiday property is you have a closing attorney, Chad Henderson, sets up to close the property. They're aware of my client's second lien on the property. RPL, Triad, Aristos, I don't remember which one, holds a first lien on the property. They end up getting paid off at closing. RPL, Triad, Aristos, because they held the first lien. We held the second lien, but magically an unrecorded copy of the forged release gets sent to the closing attorney. Now, all of them are a little cagey about how it happens, but it's our contention that came from Ms. Stahl. And Ms. Stahl did that and admits to doing that in respect to another case.
Admits to supplying it, forging it? What does she admit to?
Supplying it. She was holding it in her possession. She sent it over. I gather she if you look at the email train, which we attached, that Mr. Henderson is involved in, he was under the impression that it was being filed by her. It was never filed by her. She holds it in a drawer. The first gets paid, and then money that should have come to us, it was roughly $87,000 and maybe more than that, ends up going directly to Summit and Crown and Walt Higgins, and they turn right around and write a check. They turn right around and wire it right back out to Triad Aristos RPL.
So you're diving a little deeper than I
Sure.
need us to go right now. So given Ms. Stahl's role as you've just described it, why was it okay to talk to her without going through RPL's counsel if she was effectively an agent for RPL in, it sounds like a number of these, but in particular with Ormwood? That's the part I'm not following.
Judge, I didn't know any of that until she came to my office. They should have disclosed that in discovery.
Oh, okay,
When I asked
maybe,
about the-
and I'm gonna let RPL's lawyers respond in a minute, but at some point pretty early on in your conversation with Ms. Stahl, a light bulb ought to have gone off that, wait a minute, I've stumbled across you because I've seen your name on some documents, but now that I understand the role you played, we ought to stop. And I've got an obligation to reach out to RPL's attorneys and maybe the court to say, why am I learning about Ms. Stahl this way? There's an issue. You aren't getting me what you ought to get me. She should have been listed in the interrogatory responses. She's got a whole bunch of documents that you ought to be getting. So either Ms. Tuttle, you and I need to work this out, or Ms. Tuttle, you've got some explaining to do to the judge as to why Team Myers is only stumbling across this and it wasn't handed to them with a bow on it, which it sounds like it should have been. So why did that not happen?
I could have handled it that way. It didn't occur to me at the time. I will also tell you that I reached out to opposing counsel because I was concerned about the volume of documents I had gotten. I still don't think I have them all, but the volume of documents I got, and I said, you guys need to, you need to look at X, Y, and Z and respond to my document request. And the response I got back was, well, you've now got all the documents from Helen Stahl, so we're good. And I had also asked to take, I think I also asked to take the deposition of Triad Aristos and was told no. And that happened very late in the discovery process, Your Honor. I will tell you, and I haven't spent a ton of time looking at the bar rule. I could have handled it that way, and perhaps I should have, but the bar rule talks about getting involved with somebody who is unrepresented. This is not an employee or somebody who of RPL. This is a lawyer. I mean, and arguably you can make the argument that a lawyer is representing herself. So, I could have gone to Ms. Dortch, and I don't have to talk to them to do that. And she's a closing attorney for them in exact the same way. She has an attorney, and that's Ms. Smithers. At the time, it didn't occur to me that we were handling this lawyer any differently than any of the others. I didn't really understand the full extent of the involvement until we really sat down and went through all of those documents. I mean, you can see, we pulled some out, and I don't think I've done anything wrong here to the letter of the statute or the spirit of the rule. I understand it looks a little bit unusual, but there's many times in these cases where you reach out to somebody, you don't know what they're going to do, and you say, I want your documents. This is not a deposition. It's a sworn statement. I mean, I can take statements. It's no different than a statement that gets attached to a motion for summary judgment, like an affidavit. And if they had identified her, I wouldn't have done it. I really wouldn't have. But the manner in which we dealt with all the other lawyers in this case, she didn't strike me as any different. And you can tell I'm not afraid to add party. I'm not afraid to name parties. And if I thought her wrongdoing was to the extent that it was, I probably would have named her in the beginning. But I just, it started with the initial discovery responses. I also went back and looked at Summit and Crowns to see if they identified her, because she represents both of these parties, and they don't identify her either as anybody who has any relevant knowledge.
Okay, that's a helpful perspective. Let me hear from one of the lawyers for RPL as to your thoughts about this. But start, please, with a response to the question of why was it that Mr. Jodecki had to stumble across Ms. Stahl? Why would she not have been included in the list of names of individuals who had information about these various problematic transactions?
Well, Your Honor, I'll start with that, and Ms. Tuttle certainly has her perspective. In the first place, as Your Honor noted, Ms. Stahal was identified by name on one of the exhibits that was attached to the original complaint, which was the Ormwood quitclaim deed of release that was allegedly forged. At the top of the document, it says, "Please return to Helen Stahal." So from the very beginning, plaintiff and plaintiff's counsel knew of this woman. Plaintiff also—
Okay, but that dodges my question.
Yeah.
Plaintiff was also aware of Summit and Crown, but if they ask lawyers for Summit and Crown who has knowledge of these allegations, there's an obligation to list Golhar and Higgins. So that doesn't excuse not including her when she seems to have played a not insignificant role in making the transaction occur. So what's the answer to the question, why was she not included in response to interrogatories?
The answer I can give you, Your Honor, right now is I don't know the specific interrogatory requests, how they were phrased, and specifically what was responded. What I believe my thought process would have been is if this was a lawyer who closed some of these transactions, that work was being done for the clients. They're not, if you wanted to make a request for their files, make it through us. But the work that they did was on behalf of the clients. It's not generally discoverable. And I just want to note to Your Honor, Mr. Jodecki is making a variety of representations about information that he's allegedly learning through emails between Ms. Stahal and various people that he thinks are his clients and discussions they allegedly had. I mean, so much of that communication that Mr. Jodecki is referencing would clearly be either attorney-client communication or within the attorney work product. And the point that we're raising, Your Honor, is that RPL was never provided the opportunity to invoke its privilege. It is not a privilege for Ms. Stahel to waive for whatever reason. The other thing I wanted to raise is I think Mr. Jodecki's notations of timing to the court is a little bit off based upon what I presented to the court, because Mr. Jodecki took the deposition of RPL, I believe it was in March of 20. It was in the very early days of the pandemic. We actually met in person before everything really got locked down, and asked a variety of questions and learned the names of all of these people. The letter that we attached to our motion was from June 26, 20. And that was the letter to Ms. Stahel that enclosed a potential deposition notice. That letter is making reference to the closing transaction with Resolutions team. It's not specifically making reference to my client. But the reason that we think that letter is significant, and you can understand why Helen Stahel possibly did what she did, and we think it was inappropriate, is the first sentence of the third paragraph, which states, "It is our understanding that the forged cancellation may have been provided to the closing attorney, Chad Henderson, by your office. We are currently investigating and wish to speak with you about this and review your file." I mean, honestly, Your Honor, the language there is suggesting that there is a target pointed directly at Ms. Stahel. But the point is, if Mr. Jodecki believes that this witness has information that is relevant and material in the case, what one does, regardless of whether or not a witness has been identified by the other side, is to send a notice of non-party discovery to everyone so everyone knows that you're seeking that discovery. And that is an obligation regardless of whether that person has been identified, because litigants all the time send notices of non-party discovery to people that they think are relevant, regardless of what somebody else has said. And that's what could have happened here if that had happened in June. And so specifically on the timing, though, Your Honor, because
well, let me follow up on your point. It didn't happen. What you believe the consequence of that not happening is that I shouldn't consider the exhibits that flowed from it? Or, I mean, in your experience, what is the sanction, if any, other than one side saying, well, gosh, you know, what you ought to do is X, but no one goes to jail for that, and maybe someone gets frustrated? Or is the sanction that discovery obtained when there hasn't been notice of non-party discovery is excludable?
Well, Your Honor, I think that if the requests had been made pursuant to what we contend are the rules, there would have been an opportunity to object. There would have been an opportunity to assert that certain categories of these documents are subject to attorney-client privilege or attorney work product or are not relevant for a variety of reasons.
Can't we still do that, though? I mean, isn't the remedy now to say, I'm not going to look at anything from Stahl? How do we pronounce last name? I've heard three versions.
I believe it's Stahl, but okay, somebody else might have something. And Your Honor, I don't know the definitive answer to that, but also to address Mr. Jadecki's point about what they claim is the sworn statement, and he's saying it's just like an affidavit. Respectfully, it is not. If you just peruse it briefly, it was an hour and a half, hour and 15 minutes with a court reporter where both Mr. Jadecki and Mr. Caskey were asking her questions based upon their review of the documents as they're going along. If they had tried to schedule that as a deposition, that would have provided the opportunity for counsel to object to individual questions, to instruct the witness not to answer if the question specifically would be inducing attorney-client communication. Other objections as to relevance or materiality could have been preserved. And I respectfully did specifically advise Mr. Jadecki, and that's why we attached the letter. When we first received copies of this information and the knowledge about this communication that came with the second amended complaint that was filed on August 31st, 2020. That was the first time the new allegation was added for negligence. And that was the first time that there was an allegation that RPL should be held liable in negligence under respondeat superior liability theory for something that Ms. Stahel did. Before that action, there was no allegation that anything Ms. Stahel did or did not do that they were seeking to hold RPL liable for that. And the day after we learned that allegation, I sent a letter to Mr. Jadecki, and I specifically objected to how he had this information. And my letter said, if you try to submit this, we will object. And then with his initial motion for summary judgment, he didn't raise it. And we didn't hear a specific response back saying, I'm going to submit this. I have a right to submit it. And so it wasn't until he submitted it with his response to our summary judgment brief that it became an issue. Frankly, Your Honor, I didn't want to file a motion in limine to argue to Your Honor.
I gathered that from your motion that this was something you did sort of as last resort because you were hopeful that if any of the Stahel material was going to be used. And so the court reporter has this, it's Stahel. We're having trouble pronouncing Stahel. So I gathered that from your motion that you were filing it reluctantly, but you felt it was necessary. And I'm not finding that Mr. Jadecki was blindsided by you raising the alarm about that because of the letter you sent and the correspondence that's been going on. Here's my thought, and I need you, Mr. Jadecki, to tell me what you wouldn't be able to do today without it. My thought is, given that Ms. Stahel is a lawyer for now and played that role in perhaps more than one relevant transaction in this case, and what you asked her about was in part, was what she did on behalf of her clients, whether her client was RPL or her client was Summit and Crown. And I'm not quite sure why she did it, but she provided you with what may have been communications between her as lawyer for Summit and Crown or RPL or both. It does seem like it would be prudent for the lawyers involved, whether that is counsel for Summit and Crown, who is listening in, or for RPL's lawyers to work through that and have an opportunity to flag for me concerns that certain things ought not to be used. The cat's already out of the bag if the concern was, well, actually, that shouldn't even be disclosed. It has been disclosed. I'm a little at a loss as to why Ms. Stahel shared with you what she did, but she did. And a letter from you saying what it said is a letter from an attorney. And if that was enough to get her to disgorge what she did, it's not clear to me that she necessarily thought that through as carefully as she should have. But that was a decision she made. To everyone's point, she can't waive a client's privilege, but that didn't necessarily stop her from handing things over if they're privileged. And I'm not making that finding right now. And it may be that 98% of your response, Mr. Jadecki, is this is not privileged, it's procedural things. It's yes, the meeting is on the 19th. But the point is Mr. Tuttle, Ms. Tuttle and Mr. Allen didn't have a chance to review that before it was handed over, nor did Mr. Johnson, if it was something that Ms. Stahel gave you, Mr. Jadecki, that arguably was work she was doing on behalf of Summit and Crown. So what I'd like you to tell me, Mr. Jadecki, is can we not meaningfully go forward with your motion for partial summary judgment absent what I'm going to call for shorthand the Stahel exhibits, in which case we'll table it and take this procedural step I just described? Or can we still do that because we need to, but also move forward with the motion? Does that make sense?
I think so. I may ask a question here to make sure I understand, but let me say this first. I don't have any Stahel exhibits or anything with respect to my motion for summary judgment. I'm looking at Alex to confirm that for me. Right. So
your exhibits, the exhibits that were of concern, D and E, whatever the letters were, those are in relation to your response to RPL's motion. Well,
and let me make sure I understand this. As I understand the motion that was filed.
That's right. These are exhibits these are attached to your brief in response to their motion for summary judgment. So yes, your answer makes 100% sense to me. You can go forward with your motion just fine because exhibits B, D, and E, which were the subject of RPL's motion to strike or disregard, were exhibits that Myers attached to Myers' response to RPL's motion for summary judgment. So I didn't ask it the right way, but it's still a question on the table. Are you able to go forward with your argument as to why I should deny RPL's motion for summary judgment without D and E, or should that be tabled while we work through this question of was there anything that Ms. Stahel disclosed that perhaps she shouldn't have?
Well, I do have some of that in there. Now, if we're just talking about Ms. Stahl's, the transcript of the discussion with Ms. Stahl, I don't think we necessarily get into that. Anything that we mentioned came out of emails. She did authenticate them. Again, it's.
Well, I want to be clear. The bright line I'm going to draw for now, because of the murkiness around Stahl, is we're not going to talk about her when we are, other than some of the basic stuff that her name is on what you contend is the forged quitclaim deed and it says return to Stahl. I mean, that kind of stuff is of record, if you will. Right. But you were able to synthesize some things, whether it's the interview and the results of the interview, because of information that Ms. Stahl gave you. Anything you receive from Ms. Stahl, I want us to put into quarantine and let counsel for RPL as well as counsel for Summit and Crown have a chance to look through to say, you know what, we think that that should be put in a box and not used because it's privileged, whatever the concern might be. I don't need a rule on that. And I appreciate you've already seen it, but there are ways to manage that. If this ended up going to trial, you couldn't refer to X or Y or Z. So it's not quite the procedure we typically file, which I think was Mr. Allen's point, that had they received notice of non-party discovery, they may have required Stahl to give to them what she was going to give to you, and then you never would have seen anything privileged if you got anything privileged. And I appreciate that we're presupposing that there was privileged material in there. But when you say email from Stahl to Summit and Crown, and you say Stahl was lawyer or represented Summit and Crown, I can see why alarm bells go off for attorneys. So let me rephrase the question.
Let me just ask.
Can we go forward with RPL's motion for summary judgment if we're not going to talk about your exhibits D and E today?
Can we go forward with RPL's motion? Yes.
Okay. So let's not talk about your exhibit D and E. I haven't seen them and we won't refer to them today. I mean, they're out there. They're in some shared drive I've got. But we're not going to rely on those and we won't talk about their contents. In the meantime, are you able, Mr. Judecki or Mr. Caskey, to get to Ms. Tuttle and Mr. Allen the universe of documents that you received from Ms. Stahl?
Absolutely. My understanding is we produced those. Yeah, we produced those shortly after we got them. And Your Honor, my understanding with respect to the documents, see, I read the motion a little bit differently. I thought we were just dealing with the statement. The documents themselves, there's some communications back and forth you don't know about, but the documents themselves, when we got them, I produced them. And I also said, you guys have some time, you need to go back and relook at your own discovery responses. And the response I got back was, well, you now have the documents, so we don't need to add anything to it. So I took that to mean, okay, well, they haven't objected to any of the documents then.
Okay, and you mentioned that. So let me follow up on that with Mr. Allen or Ms. Tuttle. I didn't realize that Mr. Judecki is representing that everything he got from Stahl, he has since given to you all, which says to me, if there was a privilege issue, I would have heard about it already. And we don't need to speculate as to whether there were privileged communications, because there ought to have been something brought to my attention. Wait a minute, plaintiff is now in possession of privileged communications. We object. They need to disgorge them. Well, they did, they gave them to you, but we need to quarantine them so that they're not relied on. And I'm troubled by, and Mr. Judecki has said it twice now, that the representation from RPL's counsel was, oh, well, now that you have that, we don't have anything more responsive to say your discovery request. Put differently, why didn't they get that from RPL in response to their discovery request? So it's two pieces. One, if there is a concern about privilege, why wasn't it already raised? This is three pieces. The first one is, do you believe, Mr. Allen, Ms. Tuttle, you have all the documents that Ms. Stahl gave to Mr. Judecki? Two, if you do have them, why haven't we already been talking about privilege concerns, if you have them, meaning privilege concerns? And then three, is Mr. Judecki fairly characterizing this, he's doing it indirectly, but I understand why, as discovery that really you all ought to have given him and he shouldn't have had to ask Ms. Stahl for it? Answer those in whatever order, but they will inform how we manage this.
Well, Your Honor, and I would like Ms. Tuttle to speak to this as well. I disagree with that, and I'd like an opportunity to look back at the specific discovery request and the specific responses. Okay. But it is not my position that the documents that they received, they should have gotten from us based on what they were requesting, what the issues were in the case, and the objections that we had made to the discovery requests.
Okay. So
as to the question of have the documents that Mr. Jadecki obtained from Ms. Stahal been produced to us? I think the answer is yes. I believe that only a portion of those documents was attached to their summary judgment response, but now I have to be correct on that because I'm not sure whether or not all 800 pages of material were submitted into the record.
But set aside whether it was submitted into the record, it sounds like Mr. Jadecki got to you all 800 pages, and I'm not holding you to that number, it's your number. But you have that and have had it for months now. So part of the thrust of your motion and then today's argument is, oh my gosh, this is privileged, and why does Mr. Jadecki have it? Is it privileged? Have you looked at it? Are there specific things we should be worried about? Or it's more, gosh, the way you went about this, Mr. Jadecki, you could have obtained privileged things. You didn't, but shame on you for having done it this way, because it could have had a deleterious effect.
Well, Your Honor, I think the collection of materials contains some documents that are likely non-privileged, other documents that happen to be in the files, some that certainly would include attorney-client communication. And while Your Honor is correct that there may be a doctrine related to waiver of privileged communication if one produces it and doesn't ask for it back or something like that, I don't think we're there yet, particularly because of the fact that we had put them on notice that we objected to the use and submission of any of this information and hadn't heard anything back from Mr. Jadecki saying, I didn't do anything wrong and I fully plan to use this information. Then we would have known. You know, Your Honor, sometimes there's decisions made not to object to objectionable questions in the courtroom for particular reasons. You don't necessarily want to draw attention to it. And so I don't think that we have a situation where there is a waiver. Now, I believe,
and I may have misspoken,
okay.
But you certainly misunderstood me. I'm not suggesting that you've waived anything.
Okay.
That may be a finding I make someday, but that's not my point. My question that may have prompted you to say that was, if there were privilege concerns, why haven't you already brought that up? But you've answered that question now, because you concluded that Mr. Jadecki's non-response to your letter saying, warning, you better not use that stuff, we object. His non-response was, all right, I'm not going to use it. He didn't say that to you, but that's what you concluded. He has since used it, and now you're objecting. So I get it. There's no waiver here. I just wanted to understand your perspective as to why it was that Mr. Jadecki had to get this in such an unorthodox manner. Why didn't it come from your team directly? If it sounds like it's relevant, I haven't heard you say yet, like, well, you know, and the other reason we object is it has nothing to do with this case at all. It seems to have a whole lot to do with the case.
Well, maybe Ms. Tuttle can address that in more detail related to the transactions, but.
Okay. But why don't you add a little bit, Ms. Tuttle, and then I think I'm going to be able to table this. There is work to be done on it, but it doesn't sound like it's going to prevent us from going forward with what we were supposed to start a little while ago, which is talk about the two motions.
Just very, very quickly, Your Honor, I think it's very important when looking at this and looking at the relevance and looking at what documents were produced is the original complaint, the parties of the complaint, and roles that people played. Mr. Jadecki keeps on calling it Triad, Aristos, and RPL. Those are three separate LLCs, three different groups of members. Corporate law is very clear. These are three different entities, like three different people. You cannot just group them together. Triad and Aristos were the lenders. RPL was never the lender. RPL was the purchaser. RPL was the purchaser in the Ormwood transaction and was named because they are the current owner of the property. RPL's role in the Holiday transaction was just simply a lender that was paid off. Triad and Aristos may have had communications before, but they were not named in this complaint, Your Honor. I was never asked for a deposition of Triad and Aristos, so I'm not quite sure where that's coming from. But it's important to know these are three different entities, and putting them together is different. These discovery requests were to RPL's counsel and what RPL did. RPL's role in the Holiday transaction was just a lender against a piece of property that got paid off. Once it got paid off, it had no interest in the property anymore. So I think grouping them together is very, very inappropriate in this situation. I also think that
but that's not getting at. You're making your summary judgment argument.
No,
now.
I think the reason I'm saying that's important is when you asked, should it have been disclosed? Should it have been, all this role that was played? The discovery requests were to RPL. They were not to Triad and Aristos. And I guess that is my point.
And you don't represent them, but Ms. Stahl represented RPL in one of these transactions. So it seems like she would be someone whose name ought to have come up in discovery, assuming it was asked for correctly. But I haven't gotten the sense that Mr. Jadecki's discovery requests were narrow. So I'd be shocked if there wasn't an interrogatory to which the proper answer would include Ms. Stahl, and that didn't happen. And given the role she played in the Ormwood transaction, I guess I hear you about Aristo and Triad, but that's not Ormwood. So
it's not, Your Honor. But I think that the important thing is that I actually would disagree that a lot of these communications are Ms. Stahl. I mean, the role that Ms. Stahl played was very important and should have been part of this. This is the problem of not doing it in a deposition, because when someone is reaching out to Ms. Stahl, who happens to be a member of RPL or a member of a different LLC, it's very important to distinguish what role that they are playing. I don't think that was made very clear in this. And then there's this, that's why I'm saying it's important when you're sort of putting these all in together, is what role was Ms. Stahl playing? I think that Mr. Johnson also has some serious concerns and objections to this.
Well, I'm going to ask him in a minute. He can speak for himself. But what is your take on why Mr. Jadecki has said several times now, when he shared the Stahl documents with Team RPL, the response was, well, now we don't need to produce these because you've got them. I'm shorthanding what he said, but why was that the reaction, as opposed to, well, these aren't relevant to what's going on?
I disagree with that being the reaction, Your Honor, is part one.
Okay.
And so I think that's a major issue. I think that when these documents were produced, the immediate response was, what on earth, this is completely inappropriate, and we object twofold, Your Honor. You asked which is, I think we object to both. One, the way that it was done was inappropriate. It disallowed all these parties to not have any objections or say or clarifications or questions in a deposition or anything like that. Two, then there's the documents themselves. What are privileged? What are not? What role did Ms. Stahl play? I agree with you, Your Honor. I feel like my concern with that letter from Mr. Jadecki to Ms. Stahl, and we all pronouncing it differently, was I feel like it was a letter inviting a breach of an ethic duty. I mean, it's saying here, disclose all these documents that clearly you had a role as an attorney in. And I think separate from this, there are some serious concerns that various parties have with Ms. Stahl's actions in this. That's outside of this. But I do think we objected right away. There was other things going on in this case. There was mediations, there was discussions, there was summary judgments pending, and you have to make a decision as a counsel. How much are you going to throw in front of a court if it's not relevant? And we didn't get to all these documents being thrown in until the very last minute of all of this. So that is why there was not 7 gazillion motions filed all over the places. We were hoping we wouldn't have to get that far. We were hoping that wouldn't be necessary. By the time when we got it to this point, yes, we objected in general. And I do think that there are specific objections to a variety of documents that should be made. There are probably documents that very clearly are not objectionable, but we were hoping we just never would get to this point, Your Honor.
Okay, well, we got to it, so we need to work through it. Mr. Jadecki, something quick you want to say?
Very quick, Your Honor. When we do this with a day, I'm just flipping through my emails, and I have an email to Jefferson, August 27th. Jefferson, overall, I'm concerned with your client's responses and discovery. Very few documents were produced. Now it appears your client never even spoke with Ms. Stahl in connection with gathering documents for the production. My request sought all documents, evidence, communications, dealings, etc. with Summit and Crown. I renew my request for these records. If you're going to assert some objection, let's get on the phone and discuss it, and I will file a motion. I can break away from my commitment this Friday or later today to discuss. Let me know. Thanks. He then responds, and I got this a little bit wrong, Your Honor, but what he does is he sends me a response with some share files, and I've got 3 separate SUP files. And then it says, this should be all that our client has, much likely overlaps with what you have received from Helen Stahl. I did reach out. I'm pulling these emails up as we go, so there may be others, but there's a line of communication. It's not that I didn't say anything to anybody and then drop these things in a motion.
Okay, well, here's where we are, and then I need to hear from Mr. Johnson. I will say, and I have been at this judging thing less long than you all have been at the lawyering thing, but I've never seen a sworn statement on the civil side. Yes, we see affidavits, but not sit down, here's a court reporter, and I'm basically gonna interrogate you. And I don't mean that in the pejorative sense, but I'm gonna ask you some questions, but I'm gonna get you sworn in first. I've never seen that before. It doesn't mean people don't do it, but if it were a commonly accepted practice, I guess I would have bumped into it before. So that's a little peculiar to me. Adding to the peculiarity is that the person who was subject to that was a lawyer who you want to be able to argue, and I think you need to argue, Mr. Jadecki, represented one of the parties in the case. So a few things odd about it, but the way we're going to work through it for now is I'm not going to consider any Stahl evidence in any form. And I'm going to ask RPL's counsel to let me know, because it sounds like Mr. Jadecki wants to be able to use it. And so I'm going to give RPL's counsel an opportunity to file something, and you can take the time you need, that says either he shouldn't be able to use any of it, or he can use some of it. The way he got it was a little peculiar, but here are things that we think are privileged, and he shouldn't be able to use it all. Now, you guys can negotiate, and it may be that that's something that everyone's going to back away from, and you agree to just keep it in a box somewhere. But I'm not going to get in the middle of that part. I am simply going to give RPL's counsel a chance to make formal the specific objections to these things shouldn't have been handed over, and these other things, even though it was okay they were handed over, meaning they're not privileged, we still don't think they should be used. Part of that's in your motion, but I've heard enough now to think that there are some things Mr. Jadecki obtained that he was entitled to, and so he ought not to necessarily be prohibited from using them. And it sounds like everyone needs to look at the email correspondence a little more closely. Appreciate it's from months ago, but I know you are all advocates, but the notion that RPL knew nothing about this until it was sprung on them doesn't sound like it's quite right. That there had been some exchanges about Myers wanting to talk to Stahl and Myers talking to Stahl. It may have been that the scope of that wasn't entirely clear to RPL's lawyers, but I will give you a chance, Ms. Tuttle and Mr. Allen, to put something in writing saying, here we have specific objections, some of this is privileged, or we've got this overall objection. And then importantly, Mr. Jadecki and Mr. Caskey can have a chance to respond in writing. So I've got something to rule on. I'd like us to go forward with the 2 motions now. Certainly we could do the plaintiff's motion, because these exhibits that prompted this lengthy discussion relate to defendant's motion. But before we do any of that, I want to make sure you all understand what I've just described. But before that, even Mr. Johnson, anything you want to add from your client's perspective in terms of, I'd like a chance to review this and respond about maybe quarantining some of it, or I've looked at it and it's not going to move the needle for my clients.
Yeah, briefly, Your Honor. Thank you. And let me, before I say what I've got to say, let me just make a blanket statement. I'm going to say a couple of things. I don't want to be construed as necessarily attacking Mr. Jardecki. He's been a fine colleague to work with. A couple of things have happened. Here we are. Number one, I don't know that I have seen the Stahal emails or documents at issue. I don't know that I've received them. I'll double check. And to be completely fair on that point, for strategic and other reasons, they are not that important to me, for reasons you might surmise. So I'll look and see if I received those. And if there are any issues, I will work with Ms. Tuttle and Mr. Allen and join in whatever response they need to file. I will say there was, and I have not raised this issue for the same reason Mr. Allen and Mrs. Tuttle have said, maybe things never happen. We never have to raise these sorts of issues. We ran into an issue earlier or in the fall where I start receiving inquiries about why I have not produced certain bank records of my client. And what I was hearing from Ms. Tuttle and Mr. Allen was Mr. Jardecki had these bank records, so I must have produced them to him. Why didn't I produce them to the other side? And this was, of course, news to me. And it turns out that Mr. Jardecki had sent a subpoena to the bank without really notifying anybody else. So he got some documents that no one else saw at first. Again, not too important to me because my understanding was these documents were relatively innocuous and didn't show any stealing of money by my clients or especially Mr. Golhar. I don't really care. But, you know, we do have some concerns. Put that instance together, then put the Stahal deposition together. You know, mistakes are made sometimes. I don't know what's going on here. It's something that we'll have to look into more carefully.
Okay. I appreciate you sharing all that. And it sounds like you will coordinate with Ms. Tuttle and Mr. Allen if you want to chime in on the Stahal issue.
Correct.
All right. Mr. Jardecki, what's going on with bank records?
When my professionalism gets questioned, I get real excited, Your Honor. This issue came up, and I'll go pull the emails again, but it came up a while back. Mr. Johnson said, I didn't know you subpoenaed my client's bank records. And I sent him a copy of the subpoena, sent him the COS, sent him everything, showed him that I did. And my recollection is he said, oh, I missed it. Sorry. And that issue was resolved. I know how to serve a bank subpoena. We got it out, pursuant to Title VII. We gave the account holder time to object. Nothing came in. And then we worked it out with the bank. And I'm happy to provide that whole line of communications because this very issue came up many months ago. And I thought we put it to bed at that time. And I had a specific conversation with Mr. Johnson about that. And
and he's not bringing it to a head now. I appreciate why he flagged it in light of my surprise at the way Stahal was handled. But if it's something that needs to crystallize, it sounds like you're going to have some documentation, Mr. Jardecki, supporting the way you approached it. And
yes, Your Honor.
Mr. Johnson I didn't hear him say right now, by golly, I want this added to the issues we consider. I think it's an important point of information. So thank you both. Ms. Tuttle and Mr. Allen, do you understand what I'm asking you all to do, should you choose to do it in connection with the Stahal materials?
I believe so, Your Honor. I mean, I think certainly we will have the opportunity to go through some 800 pages, try to flag those pages that we think should be excluded for a specific reason, other than that maybe he shouldn't have had them. And I think that would also require us to go through what I'm going to call the deposition of Ms. Stahal, because there were a variety of questions related to that.
Sure, it may be that there's not a way. So two things. One, it may be that documents were relied upon because Mr. Jardecki asked her to authenticate them in the interview that mean whole swaths of the interview are, I'll call it tainted, through what I may find were privileged materials. Don't know, don't have that information yet. The second thing you all would need to work through, not in your motion, this would be, we get to trial someday in this. I don't know of what use that interview would be other than to impeach Ms. Stahl if she testified. It couldn't be admissible on its own because there was no cross-examination. I don't know how a jury would be able to consider that document. If Mr. Jadecki tried to tender the interview / deposition, unlike a deposition, it's one-sided. And so it's a great way if you're investigating something, and I'm wearing my criminal hat now, you've locked someone in. If they're going to change their story at trial, is something with which you might be able to impeach them. But I don't see, and I'm not making a formal ruling, but I don't see a way that it would be admitted as substantive evidence in lieu of Ms. Stahel. You know what we're going to do? She's not here. We're going to read from her deposition. It's not a deposition. It's a sworn statement. But a deposition is a substitute for direct and cross-examination under oath. And that's not what this was, because of course you guys weren't there, which is what's frustrating you. And I understand that, but I haven't heard Mr. Jadecki represent that it would be something that would be admissible. It just would be the kind of thing, just like if she had written a letter to him saying, oh, Mr. Jadecki, I did sign this document. And then she comes into court and say, I didn't sign it. He could impeach her with a letter she wrote saying I did sign it. So that doesn't mean that what happened was okay. That's not my point. But you keep wanting to call it a deposition. I don't think legally it could function as a deposition in the way you all are trained and experienced in using it if we were then to proceed to trial. So I wouldn't worry about it that way, but you still have plenty to worry about. So you're going to need to look through the interview, and there may be reasons that the interview ought not to be used as an impeachment device at trial if it is infected with privileged material. I hear you on that. So you have some things to read. Sounds like it's things that you've had for a while, but you didn't read them because you thought you wouldn't need to.
Yes, Your Honor. For clarification, then, if Your Honor wants to proceed forward, the way Ms. Tuttle and I had kind of handled this is Ms. Tuttle is handling the title claim issue as to the Ormwood property. I am focusing on the defense to the tort claims. Okay. The evidence that we're objecting to was submitted in response to the summary judgment on the tort claims. Yep. So I'm not sure how Mr. Jadecki can continue the argument against my summary judgment motion that I think he intended to do without reference to those, but that would be his argument. Is it your preference to move forward with the arguments related to the title claim on the Ormwood property? And I don't know that Ms. Tuttle can weigh in on that. Can that be concluded without reference to the Stahel material?
My understanding was that the Stahel material related only to plaintiff's defense against what you're calling the tort motion for summary judgment. That's the exhibits were attached only to the Jadecki-Caskey response to your motion for summary judgment, Mr. Allen.
It was a joint summary. It was a response to the summary judgment, just a response to the summary judgment. So the summary judgment, we moved on behalf of RPL, on behalf of the title issues and the tort issues. And Mr. Jadecki only moved it a partial motion only on the title issues. The response was then to our motion, but our motion is on behalf of everything. My concern would be, is there is one area in which there is an argument of bona fide purchaser for value. And if I just don't, if any of that documentation was intended to be part of that response to our BFP arguments, that would be my only concern on the title part, Your Honor.
Okay, I got it now. So I thank you for clarifying that. Mr. Jadecki, what are your thoughts about the wisdom of moving forward today on the title side, because there are competing or cross motions for summary judgment on what we'll call for shorthand the title piece as opposed to the tort piece? Can we do that without relying on any stall information, or is it just cleaner to say, let's take a break and work through what parts of Stahl's material can be used and cannot?
Give me 1 second, Your Honor. I just want to make sure I'm not, I've got Alex here with me. I just want to make sure I'm not, there's nothing I'm not thinking about that will then pop up. I'm muted now, I think, yeah. Yeah, are you?
I think there's still says click on that spot.
Oops. Judge, I don't have any stall exhibits, and I don't think I referenced stall at all in my motion, and don't think I need to. So my inclination would be to go forward and just get this argument over with, so that you could hear, this part of it.
Why don't we try? I think we've got everyone here, and you guys aren't quite cat herding, but it is complicated to get everyone in the same place. So why don't we start with plaintiff's motion for partial summary judgment, which the response to that from defendant would, of course, be their motion for summary judgment on what Mr. Allen has helpfully labeled the title piece. And so why don't we work through that, see where we get, and then we can think about whether it makes sense to talk about the tort piece, or if that needs to be tabled. Does that work for you, Ms. Tuttle?
Judge, I'm sorry. Would there be any
Yes,
possible?
Your Honor.
Can you hear me, Judge?
Yes, try again.
Could we take a quick break?
Please, yes, let's do that. Since you're not in court with me, I can't see you saying like, I need a break. So we'll take a break until you come back, okay? We may chat off the record, but just let us know when you're ready.
Perfect. Thank you so much, Judge.
So Ms. Tuttle, you're okay going forward. If we hit a patch where you think, wait, this is stall territory, it may be that we have to pause, but might as well make the effort.
Yes, Your Honor. I don't reference to any of it, so I mean I don't have a problem with that.
Okay. Mr. Jadecki, is Attorney Dortch still in the case, or is Attorney Dortch now out?
Your Honor, technically, she is still in the case, as is Mr. Barton's clients, as is the resolution folks, only to the extent I have worked out agreements with them. We just haven't documented them. And with the holidays and then the COVID and everything's kind of set me back on my heels. I promised Mr. Barton and Ms. Smithers that as soon as this was over, that was top of my list. So hopefully they won't be in much longer, but we have resolved our claims against them.
Okay, and that includes LTC Creative. I don't know which attorneys are associated with which clients.
We dropped LTC Creative early on in the case, I believe, Your Honor.
Okay.
Yeah, that'd be great.
Judge, since we are on a break, would you mind if I got off for 2 seconds and used the ladies' room?
I don't mind. We will start when you and our court reporter are back.
Okay, thank you very much. Give me 2 seconds.
All right, Judge, I'm back. Thank you very much.
Great. We are waiting. One of the attorneys took a similar break, so when she's back, we'll get started.
Your Honor, have you had any in-person hearings where everybody wants to come into the courtroom on other matters?
I don't know about the word wants, but we have on the criminal side. There are some things that because of defendants' rights and a defendant's insistence on invoking those rights, we have to do it here. Not a jury trial yet, but we've had suppression hearings where the defendant wants the witness to come into court. So very, very small scale, no big audience. But we have had a handful of civil matters where for whatever reason, one side wanted to show up. So they sit here in court. But on the criminal side, few hearings. That's a full-blown evidentiary hearings. Had one Tuesday, so 2 days ago.
And do the witnesses wear masks? Do the lawyers wear masks and speak through them?
Yes and yes. The speaker is permitted to not have a mask, to pull the mask down if there are any audibility issues. But people, the acoustics here work well enough that at least for this hearing, witness, the police officer, he had his mask on the whole time. One of the lawyers felt more comfortable having the mask down to be heard, but did not require the witness to lower them. It was not an identification issue or anything like that. So
right.
We worked through it. And we're developing some protocols. The hope is to have our first jury trial, it'll be a criminal case, of course, in early March, if the Chief Justice has lifted the ban on that. Where the jurors would sit out in the gallery and everyone would flip their tables around and face the gallery. We'll see, baby steps. All right, we've got everyone back. Ms. Tuttle is back. So we will-
Thank you, sorry, I appreciate it.
No problem. We will turn to the cross motions for summary judgment. At least initially, we're focused on what we'll call the title issue. Who owns the Ormwood property and what were the consequences, if any, of the forged quitclaim deed. And Mr. Jadecki, I'm gonna let you go first. You filed a motion. You'll get a chance to respond after Ms. Tuttle goes. And really, you guys will probably be going back and forth a little bit. My only question for now, and then I'll let you fly on it, is it your view, Mr. Jadecki, that it is undisputed that the quitclaim deed was forged, or is that something that people are still fighting about? Because you treat it as if everyone agrees that it was forged. And that's not me doubting you. I just couldn't tell from reading this if everyone agreed that, yes, there's a problem with the quitclaim deed. And really what we're focused on is the so what?
Yeah, that's a good question to start, Your Honor. I consider it to be undisputed to the extent that there's been no evidence or anything to the contrary to that. I can't get anyone to admit that it was forged, but Mr. Myers, we have an affidavit in the record that it was forged, and we have a notary stamp from somebody who has been adamant that she didn't notarize it.
Well, but then let me ask, I try not to interrupt too much, but we're done if there's a material dispute of fact as to whether it was forged or not. So maybe I should ask Ms. Tuttle, because I hear you that your client says that's not my signature, and there's a notary saying that's not my stamp. But if there are people saying we've had it analyzed and it is his signature, or there's some contrary view about the notary, then that's a jury question or a fact finder question of whether was it forged. Because as I read your motion, everything is predicated on it being forged.
That's correct, Your Honor. There's been no evidence put forth that it's not a forgery.
Ms. Tuttle, anything you want to add just on that narrow question about forged, not forged?
Yes, Your Honor. I think for Mr. Jadecki's motion, it is a material question. It's something as a plaintiff with the burden he has to prove. We don't have to prove that it wasn't. He has to prove that it was. As for the RPL's motion, it just doesn't matter. Whether it was forged or not is not an issue. It doesn't
Okay, but I don't want you to go deeper than that.
Right,
I
then
hear
that's
you
it.
then.
Then that's it. It just doesn't, it's not something we have fought because we don't think as to RPL, it is relevant.
Okay, just one follow-up question on that. I appreciate who's got the burden. Do you have any evidence you can point to in the record that would suggest it's not a forgery? Because Mr. Jadecki has identified evidence that would suggest that it is. And so I get who has the burden, but there is no question of material fact if there is no evidence that it is not a forgery, because there is evidence that it is. You're on mute.
Sorry. As for RPL, Your Honor, no, there hasn't been anything put forth because we just don't believe it's relevant. Whether or not this deed is forged is not just, it's simply not relevant to our argument at all.
Okay, got it. Back to you, Mr. Jadecki.
Thank you, Your Honor. And just so you know, and the court has it on the record, Ms. Tuttle and I agreed to share and take down on this, and we've got Ms. Tuttle's court reporter here with us. I am going to do something that I have never done before, which is attempt to share my screen and use a PowerPoint. Did I do that right, Alex? No, I didn't do that right.
You should be able to. I think I'm the host, but the way it's set up is that any one of you can share. Only one can share at a time, but hopefully it works. It's good you've got Alex there.
Yes.
Okay, yeah, bring the PowerPoint.
She's showing you where the mouse is.
Okay.
And click what guy? This guy?
Yep.
I'm pressing all the buttons, Your Honor.
Okay.
All right.
And then now we gotta go to share screen.
Where's share screen?
Let me see everything. Is that?
That's fine. I guess they get a preview of what I'm going to say next, but
I think they're on the same. He's asking if they can see it.
can you see my title page?
Yes,
It's
sir.
probably the page, my next slide. Okay. Your Honor, at the outset, before we got off on the other motion, you made a comment. I think you were right with regard to the facts that you had set out. I do want to put this thought in your head as you listen to my argument, whether or not RPL knew or should have known. You made that comment that I think they knew or should have known. When we go through this summary judgment and we look at the law here, you will see that issue doesn't matter because of the forgery. So I'm going to point that out as we go along, but I just wanted to put that in your head as we go here. Just very briefly, by this motion, plaintiff seeks the following. We're asking for a declaration that the quitclaim deed purporting to transfer plaintiff's interest in the Ormwood Avenue property is a forgery. We're asking that it be canceling the forged quitclaim deed and declaring that plaintiff's security interest in the Ormwood Avenue property remains valid and in full force and effect. And we've also asked for summary judgment based on the language contained in the loan documents that plaintiff is entitled to credit bid at foreclosure sale up to all sums remaining due and owing under defaulted notes, as well as sums legitimately incurred by plaintiff in the prosecution of this case. And I'm going to talk a little bit about kind of what the mechanics of a foreclosure sale would look like toward the end, and we'll go from there. As I understand it, I believe these facts are undisputed. There has been no evidence to the contrary submitted. Plaintiff loaned monies evidenced by a valid promissory note and properly recorded security deed, giving plaintiff a security interest in the Ormwood Avenue property. RPL and related entities were aware of plaintiff's lien and chose not to foreclose a senior security interest in the Ormwood Avenue property or pay plaintiff directly for release of its lien, and no monies were ever paid to plaintiff in order to satisfy its loan or related lien. If you'll recall, at the time that the transaction occurs, where RPL purchases, I guess is the word we'll use, Summit's interest in this property, my client's security document, their deed to secure debt was recorded. It was recorded properly. It was recorded before the sale. It remained recorded at the sale, and it remained recorded after the sale. The cancellation doesn't get filed until many months thereafter. RPL admitted that they knew this lien was out there at the time of sale. And so there's no dispute as to that. Plaintiff's loan remains outstanding and in default. There's no dispute about that.
Just so I'm clear, the loan is a contractual obligation between your client and Mr. Johnson's clients and Higgins. The loan, one way of looking at it, has nothing to do with RPL. I understand the connections, and you're going to talk about this. It's new to me, this open note or something like that later on, as to how somehow through the foreclosure of the Ormwood property, Mr. Myers ought to be able to recover everything Summit and Crown owes him. And we'll get there. But the loan is not RPL's business, correct?
Correct. Yeah, I would say that. Correct.
Right.
And then again, we talked about this at the beginning. The instrument purporting to release plaintiff security instrument was forged and fraudulently notarized. And again, that was a quitclaim deed. It wasn't any type of cancellation. It was a quitclaim deed, and we're going to look at that in a minute. We talked about the various loans we had in this matter. I don't think there's any reason to dwell on this. I think you're familiar with this at this point. We've got initially 4 promissory notes, 4 security deeds for an initial principal amount of $358,000 that included other payments and rose to $394,000, $250,061. And I want to just talk briefly about the note and the deed, and then I'm going to get into the law. But this is the promissory note, and you could see on there we've got a $64,000 initial principal sum. The promissory note calls for a loan fee or interest of $7,680. There's a late charge of 5% that's included, and then attorney's fees of 15%, $86,016.00. Even if you backed out the attorney's fees at the time of the Ormwood closing, that number is approximately $75,000 just on the face of the note. The note includes this language as well: to secure this indebtedness along with any extensions or renewals thereof in whole or in part, as well as all other indebtedness of maker to holder now existing or hereafter incurred or arising however incurred, hereinafter sometimes referred to collectively as the liabilities. Maker does hereby grant to holder a security interest in and security title to the Ormwood property. The deed to secure debt and security agreement. Properly recorded. The deed to secure debt provides throughout, and these are just a few of the sections that talk about this. But you can see that for in consideration of the sum of 10 and no dollars and other valuable consideration, the receipt and sufficiency whereof are hereby acknowledged. Essentially what this paragraph is doing is showing you that they're bargain, selling, conveying, assigning, transferring, pledging a property interest. And then you can see in the next passage, the deed is intended to operate and is to be construed as a deed passing title to the premises to lender. And at the end of that section, you can see it's given to secure the payment of the following described indebtedness. And they define it as secured indebtedness. And it gives you an A, B, C, and a D. And when you get to D, It's any and all other indebtedness now owing or which may hereafter be owing by borrower to lender, now existing or hereafter coming into existence, however and whenever incurred or evidence, whether express or implied, direct or indirect, absolute or contingent, due or to become due, and all renewals, modifications, consolidations, and extensions thereof. This deed to secure debt, which was properly recorded, secures all obligations of Summit and Crown to my client.
I assume there was similar language in all the security deeds so that your client was sort of cross-securing his Summit and Crown's overall indebtedness to him. So
There is similar
each
language.
of the properties, in theory, if this mechanism works the way you describe it, through any of the properties, Mr. Myers could have obtained full recovery through a foreclosure sale.
I believe that's correct, Your Honor. There was one deed that was filed at the end, which wasn't filed. I'm sorry, and when the language is a little different, so I hesitate to say all of them, but at least.
But most of them. This was standard.
Yeah, and this is standard language you see in security deeds. I mean, we see this language a lot. We've talked about the quitclaim deed. I mean, the only evidence is that Myers did not sign the forged deed. Myers' name is misspelled as Myers. And we've talked about Shelia Martin or S. Martin quite a bit in our brief, who is adamant she did not notarize this. Whoop. I'd also point out that this document is not filed or recorded. You see it's dated December 20th, 2016. It's not filed or recorded until March 20, 2017. And it's my understanding that this document was filed by Ms. Dortch. She claims that she filed it. And at the time she filed it, she also filed some other documents. She filed there was a first on the property. She filed the release deed for the first at that point in time. And there was a second on the property that had been released many, many months ago, if not over a year ago. And that got filed at the same time. So we know that Ms. Dorsch recorded all of these documents. I'd also point out, Your Honor, that it is titled quitclaim deed. It is not titled cancellation. This is an interest in property they are attempting to transfer.
Why does it matter that, in your mind, that it's entitled a quitclaim deed rather than a cancellation?
I don't think it does, Your Honor, but from what I can tell from the argument that RPL has made, it feels like it shifts a little bit. And I think it now rests on some notion that because it's a cancellation versus a transfer of interest in property, I think the argument's going to be there's no transfer of interest in property. I don't think it makes a difference. But to the extent there's some kind of notion that what got transferred here wasn't an interest in property, it was done with a quitclaim deed. And that's the exact same thing that gets done in a lot of these cases, which I'm going to point out as we go along.
Okay.
I want to talk about the law, and I'm going to try to cover, and I'll do this quickly, but all of the cases, because I think they're all in our favor. There's a whole line of cases. Brock versus Yale Mortgage Company is a favorite of mine because my firm was involved in it. And I can remember sitting in on discussions many years ago when we were kicking this one around. But the law is clear, Georgia law is clear that a forged instrument is a nullity and vests no title in the grantee. It's a forgery. And even when you have a bona fide purchaser for value without notice of a forgery, cannot acquire a good title from a grantee in a forged deed or those holding under such a grantee, because such grantee has no title to convey. If you've got a forgery, the law is crystal clear in Georgia on what happens when you have a forgery. And it says you cannot have a transfer based on a forgery.
So what's the remedy for the bona fide purchaser? Assume RPL had no idea that this was a forgery. And so they actually didn't acquire complete unencumbered title. There's still this lien on the property, but they paid what they thought was enough to get title free and clear. What's the remedy? If they didn't know, they didn't do anything wrong. They just need to try to claw some of that back from the seller.
Well, let's pretend they did nothing wrong for sake of the argument, because they get those inferences. But there were a number of things that could have been done here. The first is they were in a first position. I don't want to confuse RPL and Triad and Aristos, because the other side's going to great pains to separate them. But they do say in their motion that RPL could have just gone and foreclosed our client off. I'll show you why that's different. If that had happened, when we're sitting in a second position, we wouldn't be here. We wish that there had been a foreclosure sale.
Right. They could have paid the $86,000 and boom, taken care of. But they didn't think there was a lien on it because there was a quit claim.
Sure. Okay. So that's one option. We do a number of foreclosures here, and every once in a while we'll do a deed in lieu, but we're always terrified of these deeds in lieu for just this reason. So it doesn't happen very often with reputable lenders. But so that's item one. Number two, you asked me, what is their remedy? Well, their remedy is they have title insurance to cover this. My title insurance only covers up to the point of when my deed is recorded. It doesn't cover after facts. We asked our title insurance company, they denied us. You have title insurance to cover this, and if you don't want to, and I don't know.
I'm sorry, I do not interrupt most in summary judgment motions, but the Georgia law is so beyond clear that this is a reversible error for insurance to be brought up in any sort of situation at all. So I would object to all arguments about title insurance. The law is very, very clear. It will turn a case over in a second.
Well, okay, so I appreciate you flagging that. We're not in front of a jury. And my specific question to Mr. Jadecki is, what protects your client from this situation? And a factually correct and not forbidden answer would be, well, title insurance might do that. That's all he's telling me. So I'm not thinking, aha, now I don't need to worry about this.
I understand, but even in that position, even that statement alone, Georgia law is clear that you can't, insurance does not come in any of these situations. It's not an answer in, hey, what's your recovery in a car crash or anything. That is the purpose of it, is insurance. That answer should not be part of it or considered. And the Georgia law is clear that that is completely objectionable.
Okay, well, you've objected. I've noted it. It's on the record. That is one way in which a bona fide purchaser could be protected against a forgery. Are there other ways that a bona fide purchaser who doesn't have notice of the forgery is protected?
There are, Your Honor. Again, I take issue with the bona fide purchaser notion, but for sake of argument, we're going to call them that. The other avenue they have is go back and sue Summit and Crown. They have the ability to go ahead and sue the prior holder for what they have transferred. Again, if you have a warranty deed, you've got a breach of warranty. If you've got a quitclaim deed, I don't remember how they took. I think they took by warranty deed. They've got a claim against Summit and Crown, and they've got a claim potentially, I would think, against the individuals as well that signed that deed.
All right.
What they're asking you to do here, Your Honor, is they are asking you to essentially do something that I could not find any record of where any other Georgia court has done, which is just to ignore a validly perfected security interest that was transferred by a forgery. And I want to talk about each of these cases. Let's just go through them. You can see what the black letter law comes out in Brock is. This was a quiet title case. It was in the Superior Court of Gwinnett County in front of Judge Tom Davis, who retired recently. The facts essentially are this. They're an interesting set of facts. You've got a husband and wife who buy a piece of property jointly, and they get a mortgage on that property. And I gather the husband knew something was going on with the wife because they don't have a joint bank account. They have separate bank accounts. And what would happen is the husband would give the wife money every month to go ahead and satisfy the mortgage. Well, the wife used the money for other things. At some point, a foreclosure notice comes out. She goes to a friend, she borrows some money, all is good again. Then they go back into default. Apparently she couldn't stay on the straight and narrow with making the mortgage payments. She goes back into default, and rather than tell her husband what is going on, she goes and attempts to get a loan only in her name, and a lender apparently thought this was a good idea, and it's secured by the property. And when they run the title search, they see that the husband owns a half interest in the property. And they say, you've got to get your husband to quit claim his interest or to transfer his interest to you before we will loan you on and use the entire property as collateral. And that's what she does. She goes off, they give her a blank form, much like this, give her a blank form. She goes off. Of course, it ends up being a forgery. It gets recorded. The bank comes in and, gives the mortgage. And then the husband comes along later and says, wait a second, I have a half interest in this property. You cannot divest me of that based on a forgery. And it's not a situation where you've got a forged deed directly into the bank, which is what I think RPL is going to argue, that they don't have a forgery there, so they're okay. You've got a forged deed up the chain of title from the husband to the wife. And then you got the bank that comes along later and claims they're a bona fide purchaser. And by all indications, the bank is a bona fide purchaser. But the court is adamant that this cannot be transferred due to the forgery. And they say, as such, even a bona fide purchaser of value without notice of a forgery cannot acquire good title from a grantee in a forged deed or those holding under such a grantee, because the grantee does not have that title to convey. And if you look closely at this case, they then drop a footnote in the case because the bank obviously argues that they're a bona fide purchaser. And the footnote that gets dropped in the case is, given what we say about the fact you can't have a title transferred by a forgery, given our disposition here in Division 1, we need not decide whether Yale is a bona fide purchaser for value in a matter of law. You never even need to get to that analysis. The simple fact that you've got a forgery here should be the beginning and the end of the discussion. That's Brock.
So just for your pacing purposes, I need to be on a bench meeting at 12:15. I want to make sure Ms. Tuttle has a chance to give her presentation. I've noticed the way you're presenting your slides. You got 42 total, so you are barely over a quarter of the way through. You'll need to pick up the pace a little bit as you do this, so that we make sure I get to hear from Ms. Tuttle as well.
Understood, Your Honor. I really only have like 15 or 17, I think, but
Okay.
it
just says 42.
I know. I appreciate the heads up. And let me pick up a little bit. Here you've got, these are the other cases we cited in our brief, and you can certainly read them in the brief. Both sides did a pretty good job of telling you what these say. But Aurora, 2011 case, Supreme Court of Georgia. It's a quiet title case by a lender, which is similar to what we have here. And once again, you've got a forged quitclaim deed, cannot transfer title. This is another situation where the forged deed came above, wasn't directly to the litigant. Let me just make sure I'm getting the facts of this right. Yeah, the forged deed comes to somebody who then turns around and gets a lender involved, and then the lender has to jump in, and they say, and it was a forged deed. They say there's not going to be a transfer of title based on that. VAT tax group is another one. Quiet title action, again by a lender. This case is interesting. The facts are interesting in this case. It's another case that says the same thing. They cite the Aurora case. But one of the things that happens in this case, VATAX concedes in the case that the forgery was done. There were other documents that were forged, and there were issues with the deed. But this is another case that travels along those same lines. I've also cited Tate versus Potter in the brief so that you could see this is not a new concept. The court recognized this forgery issue all the way back in 1961. Another case that we didn't cite in our brief that was an unjust enrichment case, wrongful foreclosure case, was Patel versus JP Morgan Chase, 327 Georgia App 321. And I think this is a good case because it discusses what a deed to secure debt actually does. It's passing title to a lender. And it talks about the mechanics of that. There's some talk in the respondent's brief that somehow title is not at issue here. This is the main case, this Deutsche Bank case, National Trust Company versus JP Morgan Chase, that is cited in RPL's brief. This seems to be the authority that they rely on to say that we just should ignore the security deed. And I would encourage the court to read this case closely. It's a declaratory judgment case. It's also a case that was decided on summary judgment. And what happens here, and these facts are confusing. I had to chart this out when I did it. But essentially, JP Morgan asserts that it's a bona fide purchaser for value based on a warranty deed. JP Morgan ends up being found as a bona fide purchaser here, and that ends up carrying the day for them. But the court goes to great pains to distinguish whether this is a forgery or whether this is a fraud. And they say this is a fraud. And essentially what happened, near as I can tell, is you had a bunch of banks involved. And at some point in the chain of title, you had, I think it was IndyMac Bank. They had somebody sign a deed transferring their interest. It then gets passed to another bank, I believe, and ultimately another bank. And nobody could figure out who signed the deed on behalf of IndyMac Bank. And they made the argument that they didn't have authority to sign on that behalf, or they didn't know who that person was. And the court goes on to explain why the affidavit in that case didn't carry the day as for a forgery. But they go to great lengths to talk about the fact that if it was a forgery, then you wouldn't have this situation where a person signs a document while falsely holding out to be an agent of a principal. This is not a forgery or the false making of an instrument, but a false assumption of authority. That's what they decide that case on. But they go on to tell you, they make great pains to distinguish between forgeries and fraud in the execution or cancellation of a deed. Bona fide purchaser may be protected against underlying fraud in the execution or cancellation of a deed, but where a deed has been forged, no such relief may be had. And then they go on and provide the common law definition of forgery. I believe this case is very strongly in our favor and gives a roadmap as to what should happen. We have long recognized that a forged deed is a nullity and vests no title in a grantee. They say that in this case. They cite all of that law. My computer just went cold. This case, this Deutsche Bank case, is really the only authority that they rely on, and it supports our position. Let me catch up here, I apologize. And let me just, to summarize, they're asking you to do something that no court has done when you're talking about a forgery, and that's just to ignore a security interest in a piece of property. You asked me earlier about what remedies RPL would have had. And I'm not going to get into a lengthy discussion about bona fide purchaser because I don't think I have to, but I want you to understand exactly how this transaction took place, because words like bona fide purchaser and closing keep getting thrown around, and that did not happen here. What ends up happening, this is a statement directly from page 2 to 3 of RPL's brief. They blame the whole thing essentially on Paviel Dorch as the closing attorney. Once Paviel Dorch, who RPL paid to handle the transactions, confirmed she had received the original ACM release to record, RPL provided funds to Ms. Dorch to disperse. $154,500 via checks paid to Ms. Dorch, an additional $37,500 wire via a wire to Ms. Dorch was given the authority to release to S&C. No funds were provided to Ms. Dorch in connection with this closing, and that was done at RPL's insistence. What ends up happening is there is a $37,500 wire. This transaction supposedly closed in December of 2016. Well, what ended up happening was RPL had wired Ms. Dorch $37,500. This is an email from Ms. Dorch, from Mr. Rajesh Duri, who is RPL. They will be sending you funds for $37,500 to keep in escrow for paying off the second lien on 783 Ormwood. That's us, okay? Total second lien payoff will be $69,400 as per updates from Walt. Nobody ever called us for a payoff. I showed you earlier that our payoff would have been roughly $75,000 at that point. They're relying entirely on Mr. Higgins to deal with this. And when you read some of the briefs, they act like Ms. Dorch was handling this. She wasn't. As you can see here, this $37,500 is a phantom number, because on October 31 of 2016, we are okay to release this escrow amount to S&C for immediate funding requirement for Melrich Avenue, as Walt has confirmed that this $37,500 will be put back in escrow with you in the next 5 to 7 days. When you go through the briefs, and we've cited to the depositions, RPL knew that money had not been put back into escrow. They knew it hadn't been done. And they had already released this money to cover Melrich, which was another project that RPL or Triad or Ristos had an interest in, and they had to take that money to cover other debts of Summit. Once $37,500 is back in escrow, we will bring the remaining amounts for second lien payoff as well as first lien payoff to Triad, and we'll bring 783 under RPL management with no loans or liens. Well, between October and December, the plan changes. Now they're telling Ms. Dorch, we have paid S&C to take care of second lien. No additional payments will be processed through you to clear second lien. Second lien holder should sign quitclaim deed working with Walt. So they never sent any money to Ms. Dorch to disperse. You talk about what remedies they had. Okay, if they didn't want to foreclose, let's say RPL could have forced a foreclosure, could have gone to Triad and Aristos. Now, there's no evidence in the record that Triad and Aristos would have foreclosed, but let's say that they really are separate entities, and they decided they didn't want to do it. They didn't want to do it because they couldn't have a foreclosure on the record, most likely, because it would show up, and then Summit wouldn't be able to borrow money from anybody. But it goes without here and there. But what ends up happening is they simply ask Ms. Dorch to let them know when Mr. Higgins tells them he's holding a signed quitclaim deed. If it was a real closing, monies would have been paid in escrow, an attorney would have called and got a payoff, and none of this would have happened. But when you read the emails from RPL to Ms. Dorch, you can see that they controlled exactly how this was done. This is December 19, 2016. Walt confirmed me on a text that he has quitclaim deed signed by AC Meyer and going to deliver it to you. Please confirm once you have signed quitclaim deed from Walt, and we are ready to close. I can trigger following payments within 2 to 3 hours of your confirmation. They're not sending any monies to Paviel Dorch at this point. They're giving Walt with an additional amount of money, and then they're giving money to Triad and Aristos, who hold the first lien, which is well. And then they say prepare all necessary closing documents. So to the extent there's some kind of closing with some kind of, to the extent there's a statement that there's some kind of closing, there's far from it. What you have is RPL giving money to Summit. That's all that happened. And hopefully Summit gives it to somebody else. This could have been avoided with a foreclosure, with a real closing, any number of ways. The quitclaim deed that Summit then signs to RPL, this is the, Alex, this is the Ormwood property?
Yeah.
Okay. First of all, it's a quitclaim deed. So you're only getting whatever Summit has. And that security deed has not been satisfied. The second thing that's interesting here, Your Honor, can I click on this and it'll blow up? Or no?
No, I'd have to bring it up.
I don't know if you can see it on this screen, but you can see there's a recording stamp up here, Your Honor. And what you can then look at, and it may be too small to see there, but the real estate transfer tax paid on this transaction is zero. Zero. RPL is going to tell you they're a bona fide purchaser and they come up with $191,950 purchase price. But the quitclaim deed and the PT 61 form that gets filed by their attorney says they paid no consideration for this property. They don't identify an exemption code that excludes them from doing this. And they paid no transfer tax. If RPL is truly a separate entity, they should have paid transfer tax on the $191,950. Would have been $1,900 something dollars. They didn't do that. That either tells you they think of themselves as the same as Triad or Ristos, or they've committed a misdemeanor. We cited a case in our brief.
Someone give you about 5 more minutes and then I need to give Ms. Tuttle some time.
We cited a case in our brief where you had a deed that was recorded and it showed consideration in addition to of $100. It was $100 or more, and it showed zero transfer tax was paid. The court held that was not good notice to the subsequent holder of title down the chain of title because it was clear on its face they should have paid transfer tax and they didn't. In this situation, if they didn't pay transfer tax, $191,950, you've got a $0 purchase price that they've got to get passed, or you've got an invalid deed. And while it might not be noticed to the world, they knew it. So it should apply to them and it should apply to us. And our deed, this is yet another reason why our deed comes ahead in priority. Very quickly, and I think you probably understand this, but RPL contends that we simply could have allowed Aristos or Triad to foreclose. They could have conveyed Ormwood free and clear. That's true. They didn't do that. But had they done that, what would have happened is you'd have a foreclosure sale on the courthouse steps where my client could have showed up and bid on this, right? They're telling you they bought it for $191,950. There was only $120,000 owed on it. So my client could have showed up and bid on it, or my client could have stayed home. Somebody else could have bid on it. RPL could have come down and paid $191,950. That money, anything after the 120 should have flowed to my client, but it didn't. And now you've got a piece of property that, tax assessor values at $309,000. They were in the best position to prevent all of this from happening and didn't do it. And I'm going to leave it at that, Your Honor. Thank you.
One quick question. You frame this as if a proper foreclosure had occurred or had a proper foreclosure sale, but there wasn't a foreclosure sale at all. It wasn't that there was an improper one. There wasn't a foreclosure. Is that correct?
There never was a foreclosure sale. They make the point in their brief that, well, we could have just foreclosed them off. Well, it's not quite that simple. There might have been some money that flowed to us from that.
Sure. Okay. All right, Ms. Tuttle. I'm going to start you off with the question, and then you go where you want to go. Why no transfer tax paid?
Your Honor, I think obviously, again, this is something that Ms. Dortch prepared and did, and was in RPL and I would assume Triad and Aristos and Summit and Crown all relied on her to do what was proper. But I also do, and whether or not that was needed in this circumstance. I mean, but I do think that there is Mr. Jadecki attempts to sort of discount Miss Dorsch's role in this, but it was very clear that she was retained to handle this all correctly and handle this on their behalf, and it was all done. But this was
On whose
done,
behalf?
It was all well, it was on Triad and Summit. Triad and Arist. Let me go back. I think it's easier if I just sort of start from the beginning, and I think I can answer your question.
Okay.
So, and I actually, if I can now share a screen, because I think it just helps sort of outline
Share
this.
away.
Okay, let's see if I can do this. Does everyone see that?
Yep.
Okay, so I think it's just important to just look at the title on this, Your Honor, and and see what happened and what could have happened. And Mr. Jadecki is correct that RPL and Triad and Aristos are companies that have similar members. They are related, but they are not. It is very clear that there is Triad, there's Aristos, and there's RPL. They all have different members. Some of them overlap, some of them do not. Triad and Aristos are what would be called hard money lenders. They are the ones that lend. RPL is the entity that is used normally in which to hold title in situations, whether it be bought, whether it be to avoid a foreclosure, whether it be in any sort of circumstance. RPL is the entity that was always the entity that held title to property. So they are not the same, but yes, obviously they work together, but they had different purposes, which is why they were different companies. So Summit and Crown, can you all see my pointer? Does that work?
Yes.
Okay, awesome. So Summit and Crown bought this property. Okay, so they buy the property on Wormwood. This is done with two security deeds. A security deed from Triad and Aristos for $120,000. That is a purchase money security deed, and a security deed to Miss Mahajan, I'm going to pronounce it wrong, for $32K. That was again at the same time. This was purchase money security deed for this property. It was testified that this was to help renovate. The property was not in the best shape. The goal at the end of the day was for Summit and Crown to do work on this property, to improve this property, to pay it off, and then to sell the property. Obviously, that was the ultimate goal, and for everyone to get paid off. So that is done first. We have the security deed a first, and we have a security deed a second. After the fact, after this purchase money transaction in which Summit and Crown buys the property with the money that is given from the purchase money security deeds, a third priority security deed is given here to the plaintiff for $64,900. There's a lot of testimony in Mr. Meyer's deposition, and I know that you have enough to do already, Your Honor, but I think his deposition in totality is very telling. Mr. Myers did extremely little investigation or work or anything on this. It's funny that Mr. Jadecki says that we were wrong. How dare we just rely on Mr. Higgins when it was his client's testimony throughout the deposition that that's what he did. He was relying on Mr. Higgins to tell him the truth. He was relying on Mr. Higgins to do this. He did no investigation whatsoever before this. In fact, he testified he didn't even know what priority lien he was. He actually thought he was a first priority lien on this property. He had no idea any of it. He never did a title search, anything. He admitted he retained Mr. Campbell to just do the notes, but there was nothing, no investigation was ever done on this property whatsoever. He gave money to these gentlemen with an extremely short period of time, high rate of return. This was a 6-month note that he was supposed to make a very high percentage on, and just did it blindly. He did not even know the condition of the property, didn't know if it was vacant property, didn't know.
But that doesn't have anything to do with the forgery, and I mean, connect the dots for me.
It does, Your Honor, and I'm telling because there's equitable relief that is being asked for in this case, and so the equity of all sides needs to be looked at. And I think so. I do believe that Mr. Myers' choice to turn blind eyes constantly and to just sort of turnover money with no investigation whatsoever does play a role, because he is asking to be put in a better position than what he was in when he was originated. And that is very important. He's asking to use this, let's assume for the sake of argument, it is a forgery, use this forgery to better his position. And that is completely contrary to the rules of equity. The security deed gets granted here, so that's a third priority lien. Your Honor, RPL then, this is all undisputed. RPL then purchases the property. So this is a purchase that RPL gets the property here. Okay, so they then are purchasing the property. It is undisputed that $60,000 was paid to Triad. It is undisputed that there was $60,000 paid to Aristos. It is undisputed that there was a check for $33,450 was paid to Summit and Crown. The testimony was that just like, and obviously everybody is looking at, everyone can look back and say, why did anyone rely on Mr. Higgins? But the testimony was Mr. Higgins told them about this third priority lien, but I'm paying it off. This was a reimbursement for a payoff that they believed had already happened. RPL believed that ACM, so Triad and Aristos get paid off through the 60K, so that goes away. The security to Majahan had already been paid off, it just hadn't been released. And then they believed that this security deed here to ACM, that had been paid as well. They believed that Higgins had paid this off, had paid it off. The payoff amount even changed a little bit because Higgins said the amount changed. So these two payments here were reimbursements for what they believed had already happened. They had already believed that this had been paid off. They had specific instructions. We're not doing anything. We're not doing anything at all until we make sure that this cancellation, the original, is in the hands of the attorney. The attorney has it. The attorney has the deed, and the attorney is saying, you're good to go. And that is exactly what happened. The original cancellation, and it is a cancellation, Your Honor. If you go to the quitclaim deed, and I think I can change to that as well. Let's see. And it does make a difference. Let's see if I can, let's see. I'm trying to, I'm trying to find the one, well, I guess I don't know if I can do that. So, but if you look at the language of the quitclaim deed, I can find, I have the wrong one up. I have the one to Triad and Aristos. But the quitclaim deeds, Your Honor, we are a security deed state. It's a very unusual state because, it's not something that we do all, Georgia is actually the only state that does it. So it is a conveyance of property. It is a different type of conveyance of property. It's subject to an equitable right of the grantor. It's subject to a right of redemption. It is a security interest in the property. So a quitclaim deed is just a very commonly used release of the security deed. In fact, the quitclaim deed for ACM3 specifically states that it was a release this quitclaim deed is being executed for the purpose of releasing this $64,900 security deed against the property. That is what it says. So RPL pays $120,000, that's undisputed, to Triad and Aristos, pays this check of $33,450 to Summit and Crown that they believe is part of the payment to reimburse Summit and Crown for the payoff of ACM. And then there's a $37,000 money that was being held to pay to Summit and Crown. Basically, all they did was not have it be paid back to Pavi, and paid again. I mean, that's the only thing that was done in this case, is that the $37,000 was paid. In theory, yes, it could have been paid back to the escrow account, and then Ms. Dorsch could have let it go again to Summit and Crown, but it was just literally stopping that step. All of this was $37,000 credit to Summit and Crown for what they paid to ACM. So this was all consideration that RPL paid to be a fee simple owner of the property. They had no reason to believe, I can stop sharing this now. They had no reason to believe that there was anything wrong. In fact, they did not know anything about the cancellation or anything, or even see it until after the lawsuit had been filed. They had
so let me stop you there. I assume all that's true, and assume I know that Mr. Jadecki takes a different view of RPL's knowledge, but assume everything you're saying is true. How is that ACM's problem? Isn't what you've described a reason for RPL to sue Summit and Crown? Because Summit and Crown said, don't worry, we've taken care of that second lien. Lie, they did not. They did not do that. Your client relied on it to their detriment, but that's not ACM's fault. I mean, what we see as, again, just assuming facts as they're being presented here, the common villain is Summit and Crown. It did something that was fraudulent to ACM on lots of fronts, but in this one instance, there's a forged quitclaim deed. The fraud perpetrated on your clients is Higgins or whomever, I'm going to call it Summit and Crown for shorthand, saying, don't worry, we took care of that second lien, push us the money. I mean, I don't understand how RPL being ignorant, maybe it didn't do its due diligence, RPL being ignorant of S&C's malfeasance means that the plaintiffs don't prevail on this Ormwood argument of the whole transaction has a hiccup in it because that lien was never canceled.
And I can answer that, Your Honor. I can answer that. And I do believe that, I mean, obviously there's, listen, and there's obviously different remedies we can take. Mr. Jadecki already has a judgment from Your Honor on the note for this against Summit and Crown. I mean, we could say the same thing on RPL. You know, sorry, Summit and Crown, or sorry, you know, Mr. Myers, the fact that you don't like that the judgment on the note is on Summit and Crown isn't good enough is an RPL's problem. You know, we own this property. We were not part of the problem. Obviously, you know, that is, I agree with that. I think, you know, I would argue RPL is a victim. I do not dispute that it appears that, you know, Mr. Myers is a victim. But what the relief that the plaintiff is asking for is the problem. All the deeds, all the cases that Mr. Jadecki cites, Your Honor, these are all a conveyance of title to property that is a full conveyance of fee simple title to property. It is not a release of a security interest. And that is what is important. When you look at these cases, Broad v. Yale, all of the cases, it says a forged deed does not vest title. A forged deed does not vest title. Guess what, Your Honor? When you go back to that picture, the deed vesting title, RPL did not obtain title via a forged deed. RPL obtained title from Summit and Crown via a perfectly valid lien. That is, there is no allegation that this was a forged deed. There's no allegation that the conveyance to RPL was via a forged deed. The important part that is being missed in this is a cancellation of a security deed, a quitclaim deed of release of a security deed. Title did not fall from that deed. In all of these other cases, they say title from a forged deed fails. That would be if the Summit and Crown deed to RPL was forged, then that would fail. And then everything after it would fail. That is that line of cases that it would all fail. It is very important.
Let me push back a little bit there. And I have not read the cases. I have my homework cut out for me, and I will look at both sides set of cases. But I think, and you all are the property law experts, but I've heard enough lawyers tell me this that I'm comfortable repeating it. Summit and Crown can only transfer what it has. And it did not have fee simple title to Ormwood. It had a bunch of it, but not all of it. It didn't have the piece that Myers had. And it couldn't convey that. The only person who could convey that would be Myers, and Myers never did. There was a forgery. And so RPL may well have acquired free and clear Summit and Crown stake and interest in the property, but there's that little barnacle stuck to the property called the lien, whatever you want to call it, but it's ACM3's interest in the property. So why does the Brock versus Yale mortgage methodology not apply to that little piece?
Because it's a different type of conveyance, Your Honor. And the only thing that doesn't apply, I'm not saying, here's what the thing. If the title wasn't an RPL, then there'd be no problem here. If he was just trying to get his deed revived, because what he is seeking is this is what he's seeking. He's seeking that this quitclaim deed be canceled of record, and that his security deed, which does not exist anymore per the Georgia real estate records, gets revived. He can do that. He absolutely can do that. I do not disagree that he can't do that. The question is, can he do it against a third party? If this was just against Summit and Crown, we would not have an issue here. He could revive his security deed, no problem whatsoever at all. The problem is the property had been transferred to a third party. And where that makes that different from the Brock v. Yale cases and the other cases is there's been a conveyance to a third party, not from a forged deed. There's been a conveyance from an actual transaction where it is undisputed that money was paid. It is a fraudulent cancellation. The importance of that is that that's when bona fide purchaser comes into value. I'm not saying that we have a two-pronged issue here. One is, okay, can you revive the security deed? Okay, maybe you can. If it's forged, maybe you can. The problem is the next step. You got to go to step 2 when it has a third party in a situation like that. And is RPL a bona fide purchaser for value? And I would argue absolutely yes. RPL is a bona fide purchaser for value. They paid all this money to pay it off. They had no reason to believe it was fake. In fact, Mr. Myers testified, I said in the deposition, and do you have any reason to believe or any evidence to support that RPL knew that the quitclaim deed was a forgery when they purchased the property? And Mr. Myers said, I do not know that they would. The only evidence he
Do you have any cases though? I'm following you now. This was a helpful clarification that your point isn't that the security deed couldn't be revived. It's just that it's not revivable against this innocent third-party purchaser. Is there a case that says that? Because the way I would think the logic of Brock would be applied here is that that security deed is revived and it exists as a lien on the property for whoever owns it now. Because in fact, legally, RPL didn't buy everything. They just gave S&C some extra money that S&C wasn't necessarily entitled to because they didn't do their homework in the same way that you fuss at Mr. Myers for not doing his homework. They took Mr. Higgins at his word. Don't worry, we took care of this, taking care of it illegally by forging a quitclaim deed. So what case or cases get to that level of precision to say, we appreciate what Brock says, but in this setting, it doesn't apply?
And Your Honor, I think it's important. I do believe that I think that the Deutsche Bank Chase case that Mr. Jadecki cited does distinguish that. But I also think it's important to just go back to bona fide purchaser and how Brock v. Yale came about. It's very clear, Georgia law is very clear that a bona fide purchaser for value without notice of an equity will not be interfered by equity. A bona fide purchaser can't be set aside. Until Brock v. Yale, bona fide purchaser actually used to trump forgery. All the case, there was the Mabra case and all those cases.
Okay, but it doesn't anymore.
It does not anymore. But the case line on this is actually very limited. I believe there's actually a reason. I think that no one wants to see which way it distinguishes, Your Honor. And I think that is a question. And who knows? Maybe this will be the case.
Maybe we'll get there.
That does distinguish it.
You guys would be famous.
Yeah, I think that when you look at the case law that has come from Brock v. Yale, it is very limited in circumstances because it is picking against two victims, right? You're picking against two victims and what it is. And I also think it's very important that none of these talk about equitable subrogation. None of these talk about other equitable relief. They just say that the deed trumps bona fide purchaser for value. So I believe that when you look at these cases, it's important to see what they don't say and what they're limited to, because forgery law in Georgia is a very serious relief. It's a very severe relief. And I think it has to be looked at in the limited approach that it is. And bona fide purchaser applies everywhere. Bona fide purchaser is an overwhelming, that's OCG 23120 that applies to everything. And I think that, that is basically the forgery is a small separation from the bona fide purchaser law and has to be looked at in that vacuum of what it is. If you look at all these cases, they talk about how title fails. There is no title that is failing from this. I think it's also very important, Your Honor, when you go back to this, hold on, back to my shared screen. Let me see if I can do that. Of the position that is being asked to be in this case. how do I go back to share screen? Okay, hold on. Sorry, technical things. Okay, so back to my lovely drawing of where things are, okay? In this case, when Mr. Myers was originated, he actually was originated down here. What he is asking for is to take advantage of this cancellation here, take advantage, I believe this was canceled beforehand, but it was actually of record when Mr. Myers gave his security deed. But let's even take that out. He wants to take advantage of this payoff, from a transaction he says stemmed, I guess, partially from forgery, just his, and he wants to take it so that RPL is subject only to this security deed, taking advantage of the payoff of this purchase money security deed up here and whatever happened to this here. He cannot be in a better position. Had there been, let's say Mr. Myers had come back, there'd been an actual communication that between them and they talk and he says, or maybe Pavi goes and talks or whatever, and he says, it's $90,000 payoff. The payoff's $90,000. RPL could have just said, well, no, then we're not taking the property. We're not going to pay that much for title to the property. And Triad and Aristos could have foreclosed. Triad and Aristos would have foreclosed at the 120 amount or whatever was owed to them at the time. I don't know what the specific amount, they had interest and payoffs. So whatever was owed to them at the time. Interestingly, in Georgia, there is actually no requirement to give notice to junior lien holders, but they would have foreclosed. The only way that Mr. Myers would have been paid anything, he would have been paid not a dime had the property gone back to Triad and Aristos. Not a dime. The only way that Triad and Aristos would have, in any way, shape, or form, had any of it been paid to ACM, it would have had to go to third party. It would have had to completely pay off whatever Triad and Aristos debt is, and then it would have flowed down, and it would have flowed down to the security deed of the 64-9. He does not only want to have RPL be subject to the 64-9, he wants it to be subject to like a $350,000 debt of all the other debt on the other properties. So here he was, a $64,900 third priority lien, and he's asking for what is equitable relief to set aside a cancellation, to revive a security deed, and he wants it to not just be 64-9. He wants to be able to do all of the debt from the parties, all of his security, all of his interest, all of his attorney's fees and everything, such that it's a $300,000 or $400,000 first priority lien against RPL. That's just simply, when you look at this as an equitable relief, that is not an equitable resolution. That is not what the intent of any of the protections of this, let's call it forged or fraudulent cancellation is. If you believe that he is entitled to a lien prior to RPL, if you believe that this lien should be revived, that RPL either does not qualify for a bona fide purchaser, which we believe it absolutely does. If you do not believe it applies, and this is 64-9, this jump to some argument that it should now be some $350,000 lien against a third party who everybody admits was not part of the debt between ACM and Summit and Crown. He's looking to jump ahead into a massively unequitable better position. This is he's saying, Your Honor, guess what? I'm the subject of this forgery, but I'm going to benefit from this. I'm going to now I want to be able to jump ahead and be in a better position. The purpose of all the law of setting aside deeds is to put people back into the situation that they were supposed to be in. If he wants that set aside, he's got to set aside the whole thing.
But wasn't Mr. Myers in a position where he had a lien on the property, the language of which secured him against all the indebtedness of Summit and Crown? In other words, it's the language, I mean, you saw it, it's baked into the deed, it's baked into all but maybe one of the agreements that Mr. Myers had with Summit and Crown. So back to people not doing their due diligence, I'm not sure why your client didn't read what that lien said, but that lien seems to say that it secures Mr. Myers as against all the obligations of the grantor, which would have been, I'm using the wrong term, but would have been something Crown, which could get you to your 300,000. So why does, if what Mr. Judecki is asking for is reattached the lien to the property. It was improperly stripped away. And that lien always gave Mr. Myers the ability to seek to collect, should he foreclose on it, all the indebtedness of the grantor of the security deed. How is that putting him in a better position?
Because Your Honor, he was always subject to other debt. He was a third priority lien when he was against the property. And even though you're reviving it, this is still equitable relief that he is asking for. So you're reviving it. He's asking you to revive it as to the note and security deed between a completely third party. You're looking to revive a security interest. Basically, it's almost like an equitable lien. You're looking to put a security interest back against a completely third party. Again, if this was Summit and Crown, I think the language is more limited in these security deeds than Mr. Jadecki wants. I think it's limited to the interest that the party has in the property as a whole. I don't think that it gives you all of a sudden a much larger lien against the property. I think that if it's
Sure.
paid off to some, and there's other debt that brings you up to that amount, you can pay it off. I don't think it gives you a super lien against the property.
And you may be right, but do I even need to reach that? I mean, isn't the extent of my authority, should I choose to exercise it, to simply say that lien is reinstated? And I know that Mr. Jadecki said, I want you to declare some other things, but I can't rewrite the lien. The lien was what the lien was. And if I find it was improperly stripped away equitably, it ought to be put back on there. That may have consequences for people. One consequence may be that if there is an effort to foreclose on it, Mr. Jadecki and his client learn that the most he could get for it is the money he put in for that property, plus interest, like you're saying, Ms. Tuttle. I don't know that I need to reach Mr. Jadecki's third form of relief, which is I also want you to declare that I can recover nearly $500,000 now through this little lien on this one property. He may be right, but I don't think that I need to get within 1,000 miles of that issue at this juncture. The threshold question is, was it properly extinguished? And if it was not, what should happen? And you are arguing that what should happen is he should sue Higgins and Summit and Crown and try to claw back his funds that way. And you may be right. I need to work through, is there also equitable relief due to plaintiff because of the forgery that occurred? So I hear your incredulity that your client could ever lose money out of this deal beyond whatever is owed, whatever Summit and Crown owed Myers on the Ormwood property only. It seems like doubly inequitable if your client ends up being liable, absent some finding that they were co-conspirators, et cetera, which we're not talking about today because we don't have time, and you all need to work through the documents from Ms. Stahl. But if it's cabined to Summit and Crown would have owed you X dollars on the Ormwood property for the Ormwood note, then I don't think we're getting into the area that got you most energized, Ms. Tuttle, that somehow your client could be stuck losing money beyond the amount that Summit and Crown misrepresented that they had paid off on that third loan. Does that make sense?
It does, but I do think that the big thing that's missing here, Your Honor, is the two-step process, is whether or not it should be revived, and then what the effect of the revision is equitably against a third party. And I think it's a two-step process that needs to be looked at.
Okay, but then take me to the second step. So let's assume it's revived. How could it be revived only as to Summit and Crown? It's a lien on what? And there's nothing securing it anymore.
Right. So that's why it becomes, that's why it comes to the second question is, okay, if it meets the qualifications of being revived, but it's been sold to a third party, what happens? And that's the next step. You have what I believe and argue is an innocent third party. That's the next step of the question. And that's the equitable relief, Your Honor, where absolutely question is, okay, one, should it even be revived? And then two, to what extent should it be revived? Because keep in mind that Mr. Myers, well, first of all, I guess it's important to know, just for the record, the plaintiffs are Mr. Myers and ACM3. Mr. Myers has no personal.
I know you've got a whole argument about that, and you could be entirely correct. I don't think it's going to change the outcome.
No,
here.
I don't. I'm just putting on. So, but they want to take advantage of the payoff that were made by RPL, that are undisputedly made by RPL, but they all don't want to take, they don't want to take, they want their part of that to be set aside. And again, the whole point of this is real property is equity. It's supposed to put people into the positions that they were intended to be in. It's supposed to look at equity as a whole. That's why bona fide purchaser is so important. The problem here, and why it does come to that second step in my belief, and why it is separate from the cases that have been cited by plaintiff, is that you do have two parties here that we could call victims, right? And so what do? How does the court balance that when you have two victims? When you have two victims that are here, what do you do? Obviously, I have the argument that step one is when you look at the equities of the parties, the actions of the parties, we believe that RPL is a bona fide purchaser value, and we believe that the plaintiff did not take any of the steps it should have taken to protect its interest. It could have started foreclosure proceedings when it went into default. It could have reached out to the first priority lien holder and paid it off and become a first priority lien and foreclosed. It could have done all of that. They chose not to. So there's one. But two, okay, let's say I am going to revive the lien. They're like, fine, I believe that it should not, one, be revived, and two, be revived against the property. I do believe, Your Honor, that it needs to be looked at as what does that lien, what is that limited to? Because it is extraordinary relief that is being given against a third party. So the best case scenario in my mind is that Mr. Myers gets put back into whatever position that he was at the time of that fraudulent cancellation. That's his best day at the office. The best where that was a third priority lien against a property. So equitably, what do you do about that? He was a $64,900 third priority lien against the property. And as a side note, you said, well, why didn't your client read the language of that security deed? Keep in mind, my client was just the buyer. The security deed was written after that tried and Arista security deed, and we believe that it had been canceled. We were told that there was a cancellation, an original cancellation that had been obtained by an attorney who said they were good to disperse. So,
all right. Well, lots of people were told lots of things, and I guess one shouldn't fuss at one party for not reading the fine print because someone told them everything is okay, and then think it's okay when your client engaged in the same non-due diligence. But anyway.
I agree with that on some documents. I disagree that on the language in that security deed, and I disagree with what it is. But
let me ask you another question then, please. I'm with you that Mr. Myers, or plaintiff, I'm just say plaintiff ought not to be put into a better position than before. I'm not sure that I would have the authority to do anything other than reinstating the lien, the security deed. I don't think I could rewrite it to say, and by the way, the security deed it has to be treated as a third priority. I mean, there's no third priority anymore. If that gets reinstated, I think it's the only lien on the property. There may be other things now, but those other lenders that you've indicated, they've been taken care of in a way that Myers wasn't. But regardless, I don't think I would have the authority to take a blue pencil to that which was improperly canceled to say what I'm reinstating is a shadow of its former self, or it's limited in this way, or it's structured in a different way. I can't rewrite it. I didn't write it.
I disagree, Your Honor. I think you absolutely can. I think that's the point of equitable relief. I think that it happens all the time. The courts in equitable subrogation, for example, in equitable subrogation cases, when a security deed is revived in an equitable subrogation case, it is limited to the amount that was paid off to satisfy that security deed. And it is so that security deed in that same situation, when you ask for equitable subrogation, you revive a prior security deed to the extent that it was paid off by the person seeking equitable subrogation. So yes, absolutely. I think the court absolutely can limit it. It's done all the time. It's no different than an equitable subrogation case in which it's limited. And the purpose of that, Your Honor, is let's say the security deed was $300,000 that was prior, but it had been paid down. So the new lien holder only paid off $200,000. The courts don't believe that they should jump into a $300,000 position. They should be limited to foreclose on that $200,000 payment. It is the same situation here.
Well, Your Honor, except that the language that Mr. Jadecki is most interested in, that he contends enables his client to seek to recover indebtedness across any number of transactions between Summit and Crown and his client, that's the language. It doesn't have a dollar amount associated with it. So I would be rewriting it. I wouldn't
I just disagree with the line. I think that he wants this to fit into the very, very narrow exception to bona fide purchaser. That is that forgery law. It's an exception. It's narrow. I think he wants to fit it into that box. And it's like trying to fit a triangle into a square hole. It just is not going to fit. It has to be very precise.
Okay. Well, I appreciate your argument on that. Mr. Jadecki, any 2-minute rebuttal?
I think, Mr. Allen, Your Honor, would you allow my co-counsel to?
30 seconds, Your Honor.
Any 2-minute addition?
Yeah, less than that, Your Honor. Just to the extent that Your Honor has equitable remedies available to Your Honor to put the parties back in their own position, not arguing the amount of the lien that the plaintiff may have, but to put him back in his position, he would necessarily need to be behind the amounts of money that were paid to pay off the first and second. So I think Your Honor would absolutely have the ability, either through recognizing a rescission of that transaction, because RPL only purchased based on the representation that all minor things had been undone. And so if you rescind that transaction, Trident and Aristos have it, or you should recognize the consideration that RPL paid to Trident and Aristos and the other one, and equitably recognize a lien in favor of RPL for the amount of the consideration that they paid. Therefore, regardless of the value of the claim that plaintiff might assert, they would still be in a secondary position.
Okay, I think that's an elegant way of putting what I've been trying to work through. I don't think RPL should come out of this worse than when they started. And so at a minimum, if the way this gets resolved, this being Ormwood, is that Ormwood is foreclosed on, RPL undoubtedly, I think, ought to be able to recover those first and second priority payments. Then would come Myers, and then if there's excess, folks can duke it out. But again, I am way over my head in this because blessedly I don't have to do a whole lot of property stuff. But I don't disagree with anything you just said, Mr. Allen. And so if I am inclined to grant plaintiff the relief plaintiff is seeking, in other words, the resurrection of the security deed, I'll need to get some input from the lawyers here, because what ought not to happen is that he leapfrogs folks, although they've already been paid off. And so I guess I need to work through that. I guess it would require some thought, but I appreciate that observation, Mr. Allen, and I don't disagree with that. And I guess that's why rescission would be the cleanest way to do that, is that we just go back to before the transaction, and there may need to be a number of flows. But let me give Mr. Jadecki a couple minutes, and then unfortunately I need to go.
No, two quick points, Judge, and one's a fact point. At the time of the closing to RPL from Summit, we were in a second position. The Mahajan debt had been satisfied 6 months prior, not in connection with this. That's in the briefs. You'll see that in the facts. They've got that confused. It didn't
Okay,
get
that's helpful, because I keep hearing Ms. Tuttle say that your client was third in line. You've always said second in line, and I never heard of this middle debt until the interactive sheet we had with the hand-drawn arrows.
And that's because they've been satisfied sometime prior.
It was open of record.
Okay,
They had been
They were
satisfied.
third when they loaned the money.
are you killing the court reporter one at a time?
The reason is they had been satisfied sometime prior in a separate transaction. That's what RPL testifies to.
And plaintiff had been third at the time it extended the credit.
Okay.
And then the second point is, Your Honor, I appreciate Tuttle on the law and have a lot of respect for her, but ask her to provide a case that says you start to split this up this way. RPL is the one that controlled the method that got us to this point. My client would tell you, nobody even recognized my security interest. He's not in a better position no matter what happens in this case. So, to the extent, look at the case law and see what they did. You reinstate the debt. then we have to make a decision on a foreclosure sale, how far we think we can go. And then you see where you are. I mean, it may just be the note, it may be more than that. There's foreclosure strategy that goes on there, but we should be entitled to foreclose.
So here's my thought. One, this has been real helpful. Two, what I heard Ms. Tuttle say pretty clearly is there's not a whole second line of cases. She is saying that I should read Brock versus Yale with Deutsche Bank in mind, and that her contention is the thrust of Brock simply doesn't apply in this setting. She's drawing a distinction that you disagree with, Mr. Jadecki. So I'll clearly get up close with the cases. I suspect that I'll be asking for some input from both sides about what equitable relief would look like if I am granting it. And this is along Mr. Allen's point, because I want to ensure, I believe I should ensure, but I think about it more, that RPL doesn't end up worse off if plaintiff's security interest is restored. Now, worse off in the sense that there's a lien on the property. That's life. There always was if it never went away. And it sounds like it never went away. People pretended it went away, but it didn't. There was a whole bunch of money that flowed from RPL to others to acquire the property. And if the way a foreclosure might work would be that RPL gets nothing for its investment, that is an inequity to RPL. And at this juncture, because we're not getting into the tort claims, it doesn't really stand in the position of the wrongdoer in terms of the equitable consideration. So don't be surprised.
May I say one thing very quickly onto that? And I apologize, but I do think it's important when looking at that to answer your question is to keep in mind the time frame of this, that there was a time that was waited from the default of Mr. Myers to when the lawsuit was brought, and therefore RPL has owned this property for a good amount of time and has improved this property for a good amount of time. That's also in the brief. So the property is much more valuable than it was at the time that the cancellation was allegedly, that Mr. Myers' interest was, let's say, taken away. RPL has put a lot into it. So I do think, like, if you're asking about weighing the equities, I should have mentioned that there is also a time frame where a lot of work, taxes, maintenance, everything was put into the property. And I did just want to make sure that was known to the court.
Okay, no, I appreciate that. Those are knowable quantities. And so depending on how we sort out this piece of property is going to be resolved, there ought to be ways to account for that. Again, knowing that those were steps taken while the property may well have been encumbered by a lien.
Your Honor.
So we are out of time. Homework for you all, Ms. Tuttle and Mr. Allen, with Mr. Johnson pitching in as he sees fit. You're going to review anew the stall documents, and then you will let Ms. Niles know, or you can file something, however you want to work it. We believe that there are certain things that need to be quarantined because they're privileged, and you may have your own motion, and it just be an amplification on the emergency motion that you dropped yesterday about what to do with this whole stall situation. But I see it as two pieces. There may be some things that have to be quarantined because they're privileged. There may be some things that aren't privileged. You may still have an argument about the non-privileged ones, but those may nonetheless be fair game. So work for you all. I will take under advisement plaintiff's motion for partial summary judgment as to Ormwood and RPL's title piece of its motion for summary judgment, not the tort piece. We will have to revisit that, I think, only after you all have reached a point of comfort, or at least a point of resolution as to the stall paperwork. So we're gonna pause that. Mr. Jadecki, anything else we need to cover procedurally?
I was just going to ask, since we have these other tasks and homework that we're working on, we have a pretrial order due next week. Can we push that back so we could focus on this? Because that usually involves identifying exhibits and things which may be at issue in this.
Yeah, sadly, we have to. I'm maybe even more anxious than you all to get this case off my docket. It would be, I don't think the best use of your time to work on a pretrial order if there's some things that in the end won't be in it.
Okay.
Your Honor, if you grant the defendant's motions, it goes away.
Yeah, well, we haven't argued part of the motion. I know it was a dud of a day for you, Mr. Allen, but Ms. Tuttle got to argue.
I'm
So let me
still
work
trying
on that
to- if I can
part.
fit a triangle into a square hole. I think I might be able to do it.
Yeah, well, we'll see. With a big enough hammer, many things are possible. All right, you all will take care of the court reporter.
Yes, sir.
Yes, Your Honor.
Mr. Johnson, anything else?
No, Your Honor, thank you.
All right, thank you.